Any mention?
May it please, Lordship. Lordship, I beg to mention item number 4, Lordship. Number 4, Lordship.
What's
Senior
in the
counsel is on sanction leave.
Why?
Lordship, senior counsel is on sanction
Where's
leave.
the Changrai Chugan?
He is out of station, Lordship.
I understand. He's on holiday.
No, Lordship, he went to visit his family, Lordship.
After
2 weeks, Lordship.
After a week, Lordship. 1 week, okay. Yes.
Deeply obliged.
Item number 1.
My lord, there is some quite heartening news, my lord.
Yes.
There's good news, my lord, in this matter. My lord, I've given the latest communication.
Good news.
My lord. The LIDAR survey was conducted, my lord.
Yes.
The LIDAR survey was conducted. And now it says, my lord, the lordship kindly sees the letter addressed to Chief Secretary, my lord.
Sit. Oh, sorry. Scan.
Now, one thing, Dr. Mojika, just come to para 5. Now, it says 12.73 lakh cubic meter of cutting. It's required of a hill, or is it within the perimeters of the existing airport, or whether it has to be acquired?
My lord, lordship kindly sees the last page, my lord. There's a communication dated 14th of August. Just prior to the map, my lord.
Yes.
Para 6, lordship kindly see. A draft master plan is attached here with. Additional land of 16 acres would be required for runway and safety area before runway 04 site, and 6 acres for isolation bay. Total 22 acres additional land will be required. So it appears,
So
my lord,
that means that
within this 22 acres.
excavation will be in this
in this additional land.
additional land to be acquired.
My lord.
Yeah.
Here, what has been proposed, my lord, the runway, one side of the runway is towards the highway, national highway, my lord. The other side, the land will be acquired on that side, my lord.
To the highway side.
No, other side, my lord.
Other side meaning?
Towards Shillong. It's towards Balapani, this side.
Towards Badapani, that side.
Towards the dike side.
Dike side,
Yes,
my lord.
yes.
And the aircraft will continue to land and fly from the other highway side. It will be unidirectional only.
After examining in terms of the optimum viable economic solution, runway extension by 571 meters.
My lord, it will become 2400 meters, my lord.
Has this report,
My lord, the report is on the way. It's quite a voluminous report, my lord. So we are requesting for a week or 10 days time, my lord, so to place the entire report also.
Mr. Alki General, have you received a brief of this report?
Kindly see paragraph 5, my lord, paragraph 5 of the letter.
Exactly, that you already flagged it just now. And
No,
but
and then there is
Monica
one
said
point
this is
because-
related to the acquisition of additional 16 acres of land.
22, 16
Yes,
plus.
my lord.
Acres, rather, yes.
Yes, my lord. Paragraph 5 also says that they will take care, my lord. DGCA report, this report, Airport Authority of India report says, my lord, that the state government has to ensure disposal of approximately 10 lakh cubic meter balance. So the rest of the land will be, or the art filling will be taken care by Airport Authority of India. My lord. There are two parts of it. One is 12.73 lakh cubic meters art
Yes.
cutting is required. Approximately 1.97 lakh cubic meter of art filling is required for the expansion of runway number 571 by 1571 meter on runway 4 side. The state government has to ensure that
This,
disposal of
for earth filling, there's no problem, I think. This,
Or one of the extra overburden that will be there about 10 lakh square meters, cubic meters. That has to be disposed of in terms of environmental laws, the regulations.
With just 12.73 lakh cubic meter.
Roughly 10 lakh cubic meters, my lord. 12 is the total excavation. 2 lakh will be used in the filling, my lord.
That means 2 lakhs reduced in the filling, which the state government has to provide. The 10 lakh cubic meters.
My lord.
So the remaining be 2.73 lakhs.
No, my lord, what it
We
says,
don't understand this.
my lord, what it says, total excavation will be 12.73, my lord.
Yes.
Now, out of that, about 2 lakh cubic meters will be used within the airport itself, my lord, for filling the
Yes.
lower areas, my lord. And so the extra will be about 10 lakh cubic meters. That has to be disposed of, my lord.
10 lakh cubic meters will be what, on small hill? 10 lakhs, a million cubic meters.
10 lakh cubic meters, my lord. I think a lakh trucks, my lord, or 50,000 trucks.
Because 10 cubic meters, one truck carries how much?
At the most, 20 cubic meters, my lord.
10 ton, my lord. 10 to 12 ton, my lord. 10 to 12 ton.
Anyway, today we will not pass
My lord.
only that.
Yes, my lord.
As
But
per the
today I'm
order-
praying for a week's or 10 days time, my lord, to place the entire
See, I was
report.
not part of the bench also that did this extensive touring and an inspection of all the various airports
My lord, that,
abroad and in India.
my lord,
So,
that,
like my brother here be more well equipped to to handle situations, and he has gone for physical inspection because that was earlier the chief justice has done it, but taken great interest.
my lord.
to
My
see
lord,
that.
that was in a different perspective, my lord. But now since the existing runway is to be
So that means that the inspection done by and the report generated by the amicus of no
may
use.
not be relevant at this point of time, my lord.
That means all that was done was not comes to zero.
But I'll not say that, my lord, but
Then?
that would definitely be contributing somewhere, my lord. But as it appears now,
So that means that the Airport Authority of India is going to rely solely on the LIDAR report, that's all,
my lord.
for the execution of the project. Okay.
Because this in this
My lord, if I may submit, my lord.
Yes.
My lord,
in
if I may
this report, earlier report they said that there was a hill beyond 5 kilometers, and that was
So let them
obstructing.
file. Let's see. One thing, Mr. RK General, let them place the
Yes,
detailed report, and then then we'll pass. Then orders will follow after that with regard to modalities of how the state's going to go about it. You have to come with your own suggestions. Airport authorities will
Yes,
come
sir.
with their own suggestions also how the entire thing can be done, and identification of land and landowners that has to be done also. Then
Yes,
adequate
sir.
compensation
16
and
acres, 16 acres of the land have to be
approach
acquired.
towards all those things. And we don't expect any obstruction from the part of the government with regard to approach road or any party saying that it should come from here, it should come from there. That this court will not allow any of these
Yes,
players to come.
That's support. That orders
should
will
be
be
noted
required in
also.
this matter. Yes, my lord. That orders will be
Yes,
required.
If I may, Lordship.
yes,
Permission,
Mr.
Lordship.
Pandey.
Lordship, I am appearing in this case number 3, Lordship, which has been filed in this. Lordship, admittedly, there is difficulty in expanding the airport, Lordship, as AIA had.
Now there's no more difficulty.
Lordship,
See, even you let them have a look at the report. Are
Lordship,
you already pleaded as a party? Who are you?
Lordship, I am applicant, Lordship, here in this case.
Applicant in pleading itself.
Lordship, but my application was kept pending, Lordship. I am not been.
No, are you having a rate as a respondent?
No, not
Who
yet.
are you?
Not yet implemented, my lord.
I have filed in this case, Lordship.
he is a landowner, my
An
lord.
application for impleadment?
Lordship, I filed in this case, Lordship.
No. Have you filed application for impleadment in the proceedings?
No, Lordship, not.
Then we won't hear you.
My Lordship,
My lord, here what happened, my lord, he is a landowner, my lord, somewhere else. So because we were facing some difficulty for expansion of the
Have
existing
you
runway,
impleaded himself?
No.
they are offering some other land, my lord. That is becoming infectious in view of the development, my lord.
Lordship, only submission is Lordship, my Lordship. I
That'll be
filed
for a second
one
report.
representation, Lordship. I filed one representation to the Transport Authority just to
Have you been
conduct feasibility test, Lordship. If my prayer is only with regard to disposal of my representation, Lordship.
But that's
So, my lord,
not even relevant at this point. of time.
Petition then. You're not impleaded in the proceedings also. Who is this Andrew Sutra? You are Andrew Sutra.
I am Lordship.
We'll pass orders in the main case first. Yes, communication dated 3/9/2024 has been produced before this court wherein a brief gist of the feasibility of the expansion of the current of the airport for accommodating larger planes has been set out. Stop. Next, but it's heartening to note that the Airport Authorities of India, as per the LIDAR report, have, after examining different scenarios, has found that with a few alterations and additional land acquisition of 22 acres, the airport will be viable for accommodating, let's say, larger aircraft. And it has been indicated in the said communication that consents also been received from SpiceJet for the operation of 737 aircraft. Next paragraph. Mr. Dr. Mbozika, however, praised that we were allowed to bring on the record the detailed report, which is voluminous. Next paragraph. The Learned Advocate General, appearing on behalf of the respondents, submits that the state respondents submits that they also in receipt of the communication, and once the report is placed, suggestions and modalities for implementation of the same will be worked out and presented before the court. So, how much time do you want?
10 days time.
That the report be placed within a period of 10 days for further orders in the main case. Now, in that Miss case PIL number 3, what do you want, Mr. Pandey?
Lordship, I may be allowed to file an implementation petition, Lordship.
For what now has become infructuous.
Lordship, I just pray that my representation may be disposed of.
How? But in this case now, it's totally different. You're offering land.
Lordship.
Correct. You're offering land now. You're offering land on your own accord, saying that in view of the knowledge that you have that maybe this present airport is not viable, that take my land. Correct.
Lordship, if I may add, Lordship, this honorable court had made an observation on in order dated 14th March 2022, Lordship. If I may take, Lordship.
Where's the observation?
In my application, Lordship, case number 14, Lordship. Case number 14, Lordship.
Yes. Page 14.
Lordship.
This is 14th March 2023. Now we're sitting in, today is the
September 24.
5th of September 2024.
My humble submission is not much has changed, Lordship. Lordship,
Yes, this application, Miss Case number 3, 2024, has been filed by a certain Sri Andrew Sutangan, who, however, is not arrayed as the respondent, nor any impediment application been filed in this connection. So, the approval of the application is for the application with a prayer for the state respondents to consider and examine the feasibility of the petitioner's land for construction of a new greenfield airport. Stop. In view of the order passed in the main case, and also the applicant not being a party in the proceeding, he said this case is not considered the stage dismissed.
Item number 2.
You are free to file your own writ petition.
Hello,
Yes.
Your Lordship, I'm making a mention on behalf of Miss S. Parveen. Your Lordship, she is.
Who's this S. Parveen?
Yes, Your Lordship.
Paruen.
Parveen. Yes, Your Lordship. S. Parveen. S. Parveen, Your Lordship. Your Lordship, I'm praying to file rejoinder, Your Lordship, on on the affidavit filed by respondent number 9 and 10.
What's the matter about?
This is income tax matter, my lord. Against the order passed by the income tax authorities, they've come by way of writ petition.
You mean against 148 notice? What are you coming against?
Demand order has been issued, my
Your
lord.
Lordship, Your Lordship, I'm unaware of the facts. Your Lordship, as such, she has just.
Are you counsel in the matter? Are you
No, Your no, Your
Then
Lordship.
why are you mentioning?
I'm just mentioning on her behalf as she is unable to appear before this.
No one appears for the petitioner.
Your Lordship, I humbly pray, Your Lordship. She
Yes?
just made a mention, Your Lordship. She has requested me as she is unable to come, Your Lordship.
P. Chetri has appeared. It's a counsel admit submission behalf of petitioner. Do not P. Chetri do not engage counsel matters that mentioned on behalf of the counsel appearing behalf of petitioner for some accommodation. This matter out of 3 weeks. Yes.
Item number 3.
Very precious also. It has been listed after quite long, so I need it to be the accommodation.
I said after quite long. Yes, sir, no, absolutely. Who's
Just
appearing?
2 weeks.
Who's for public prosecutor here? Oh, Mr. Guru. Yes,
2 weeks time, I think.
2 weeks time. Mr. Esperanza, the senior counsel says that some accommodation will be given due to personal difficulty. This is matter 2 or 3 weeks. You want 2 weeks or 3 weeks?
2 weeks, 2 weeks.
2 weeks suffice.
Well, it is a double murder case, therefore.
Double murder.
Double-
Sounds interesting because I don't sit in a criminal bench.
All right.
Any mention? Supplementary list, item number 1.
My lord, this is a public interest litigation, my lord.
One second.
If one matter is pending, what is the requirement of
Here, my lord, petitioner, my lord, is raising the issue as regard to the obstacles, my lord, which has been created by the street vendors, hawkers in almost all over the city, my lord.
Yeah.
My lord, almost in some places, my lord, both sides of the areas, roadside areas, my lord, these are being occupied by the street vendors, my lord, and therefore, my lord, it is creating a lot of problem as regard to the traffic congestion, and also, my lord, the kind of food, my lord, that is being served in the roadside, my lord, being cooked and served, my lord, this is totally unhygienic, my lord.
But one thing, Mr. Singh, I'm not imputing personal knowledge, but there was some movement part of government to relocate. What has happened to that?
Your Lordship, that move, they are still deliberating on that, Your Lordship. No notification or order has been
Meanwhile,
issued as
deliberating,
yet.
meanwhile, the vendors on mushroom.
That is the position.
Number of, my lord, hawkers, my lord.
Because earlier-
Again, not.
Earlier there was a
It's become, for ordinary citizens, it has become very difficult to traverse, even, these spaces, disabled people and old people. But then that other day, there's another PIL who was appearing in that Chatti that my brothers will inform me before we sat just now. You are appearing there, where the vendor issues there also. That's regard to traffic management, correct?
They have filed a status report, Lordship, and we're yet to file a reply on that report.
In that matter,
Lordship.
I think we'll club this matter together
My lord.
with that one, so at least we can have 360 kind of appraisal of the grievances of the general public.
Lord, in fact,
I'm
my lord,
accepting notice on behalf of respondents 1 to 5.
in fact, my lord,
1 to 5.
in the last occasion when my lord Honorable Supreme Court was deliberating on this issue, my lord, I have given an order, copy of the order, my lord. In that order, my lord, Honorable, my lord, if my lord can have a look at the order,
We'll do one thing, Mr. Sinkan.
My
We'll
lord.
put that matter together,
my lord.
and then we will pass at least some orders which maybe can be given effect to by the state respondents, because we have seen also. I mean, in the there has to be a balance.
Right.
We are aware of the the plight of the vendors and
The
hawkers. They need
pedestrians
to
also.
earn livelihood, but that should not be that that one side of society will totally overwhelm
Right.
the other facilities or basic public utilities of other people. Yes, Ms. N. Sinkon, Minute Counsel for the petitioner, MS Tiangi, General AAG with so-and-so, is present, accept notice on behalf of
1 to 5, Your Lordship.
1 to 5. What about
My Lord, I'm for respondent 6. My Lord, we have yet to receive a copy of the
My
petition.
lord, we'll serve a copy.
Mr. Smithson is present and accept notice on behalf of number 6.
My lord, even
Petitioner to
for
supply
town
copy.
vending committee
Then
also.
over the town vending committee is what? Town vending committee is?
We don't have instructions as of yet, my Lord. We'll be entering appearance on behalf of municipal board, my Lord. We'll see.
No, a town vending committee. What is this? It's chaired by whom?
My lord, this is part of the Shillong Municipal Board, my lord, that is to be.
Then
CEO is the
you take
chairman.
notice, 6 and 7.
Let notice be issued to them.
Let them serve us a copy.
You is under the municipality.
My lord, CEO is supposed to be the chairman of the town.
Do you
vending.
have any material to show?
My lord, act is there. And even, my lord, there is a.
Now see, Mr. Chinkon,
Yes,
Shillong roadside hawkers, who will serve it to?
The association.
Meghalaya Shillong, who will serve it to? They have an office. Is it a registered society, this Shillong Roadside Hawkers Association?
My lord, there is a office, my lord,
There is
registered
an
office
office
is
at
Gita
Gita
Bhavan.
Bhavan, Thana Road. Your
Office is there, my lord.
And number 9?
9, my lord,
Lordship.
Moti Nagar. My lord, this is one of the office memorandum issued by the government of Meghalaya, my lord. Here,
Okay, no, For the time being, I thought, no, number 6, Mr. Missile, present accept notice on behalf of number 6. Petitioner supply copies of petition to the set, respond to the set to the council. So with regard to number 7, though it is submitted that it is part and parcel of the respond number 6, Mr. Missile prays without to obtain instructions as whether it represent them. So, you think you can serve notice in 8 and 9?
8 and 9, my lord, will issue notice, my lord.
Notice to go to respond to 8 and 9 within 3 days. Now, next paragraph. It has been reported to the price to court that a similar PIL is presently pending consideration with regard to traffic congestion and other related issues, of which the obstruction by street vendors has also been raised. As the issue in instant PIL is similar to the pending, which number is it, Mr. Dakhar? Mr. Dakhar? What number is it? Ask him. Mr. Dakhar, what is he doing? You were here just now?
Yeah. You can provide later.
What PIL number is it?
PIL number. Number 17, Lordship.
17 of?
17 of 2021.
It is this matter together. The next day.
Obliged, my lord.
Daily list, item number 1.
This for admission in it.
Yes.
But this is the order, this is an appeal against the order of the learned single judge, my lord. Now here what happened, my lord, the respondent was a candidate for the post of nurse, my lord, in Assam Rifles. And she had undergone LASIK surgery in her eyes, my lord. So in the medical, review medical, she was declared to be unfit on account of LASIK, because the rules say, my lord, therefore the lower rank officers, personnel, LASIK surgery is not permissible, my lord. Of course, the rules for gazetted officers says, my lord, the LASIK surgery is permissible. So on that ground, the learned single judge held that this is discriminatory and to give her appointment, my lord. Apart from that, my lord, the learned single judge has said, my lord, if lordship kindly comes to the impugned order, my lord.
Page. Internal page of the judgment, which page?
The last page of the para 10, my lord, the operative part of the order.
Para 10.
Well,
Yes.
may I read, my lord? Upon considering the whole scenario projected by the parties, this court is of the view that there is a clear discrimination among the set of persons working in the medical industry, namely doctors and nurses, who are equally responsible for the well-being of patients. Hence, the regulation guidelines in respect of LASIK surgery giving relaxation to gazetted officers and denying such concessions to nurses cannot stand in the eye of law. For the foregoing discussion, this court is inclined to pass the following orders in the writ petition. Clause number 67 being discriminatory, arbitrary and violative of Article 14 of the Constitution is interfered with. A direction is issued to the respondents to include both doctors and nurses in the guidelines tabular column to be eligible for appointment, even if they have undergone LASIK surgery. To that extent, the guidelines are quashed. Since nearly 6 years have gone by, the petitioner shall undergo another medical examination. If found suitable, he shall be accommodated in the existing vacancy or in the next vacancy that may arise. It is made clear that without appointing the petitioner as staff nurse, if medically fit other than LASIK surgery, no other nurse shall be appointed. So, my lord, this last direction, my lord, in my humble submission has affected and has the tendency to affect the recruitments in the end, not only Assam Rifle, my lord, because the rules are not only for Assam Rifle, these are for all paramilitary forces, my lord. So, my lord, what I pray at this stage, my lord, until final consideration of the matter, the order is.
Yes.
So, my lord,
Yes, Mr. Pathak.
I don't have a copy of the petition, my lord, but then I recollect the order
Why you don't you?
My lord, I have a copy of the order.
You've been served.
I have a copy of the order, my lord. I actually missed the item today, my lord. But then otherwise I'm familiar, my lord. The issue, my lord, as my learned friend has pointed out, is that there was a distinction. There was no specific rule as such to be set aside. But then a guideline was given in which basically relaxation was given to the doctors, but then who are gazetted officers, but then the nurses, they cannot undergo LASIK surgery. This was, my lord, in my understanding, rightly interfered by saying that you have to, because they do the same service. In fact, in some ways, the nurses are more responsible in giving medicines and primary first aid care to the patients. So in that light, my lord, it was probably directed that they have to be equated. But then, yes, the third part, I agree that the recruitment as such cannot stop.
Yes.
What is required is that if I'm subjected to a review medical, I might come up good in that review medical, I might not come also. In that case, the case ends, my lord. Let them subject me to the review
That we can
medical.
dispose it off.
And the
Why
third
not
part,
setting aside condition number 3?
my lord.
well,
You're agreeable to that clause being
my lord, there also,
deleted.
my lord, we are not entirely agreeable to that, my lord. But we have challenged that on that ground also, my lord. My lord, what I was praying in the interim, my lord, lordship grants that much protection, my lord. The matter may be heard, finally. Because what happened, my lord, the rules envisage hierarchical discrimination, my lord. Now, the rules do not say doctors only, my lord. It says entry-level gazetted officers. So entry-level gazetted officers can be from medical branch, can be from some other branch also, my lord.
Okay, we'll examine it then.
My lord.
Yes, the instant appeal has come up at the mission hearing today. At this stage, the learned Dr. N. Mosika, learned DSG, has submitted that. The respondents or the appellants are aggrieved with the condition number 3 contained in paragraph 10, then in bracket Roman 3 is 1, whereby the learned single judge had directed that without the petitioner being appointed as staff nurse, no other nurse was to be appointed. This senior counsel submits has caused what it has caused
The stoppage of recruitment, my lord.
caused a deadlock and a stoppage in the recruitment process as it affects the entire
Paramilitary forces, not only asylum.
the entire parliamentary forces. He prays that in the interim, while the matter is pending final consideration, that this direction be kept in abeyance. Next paragraph, Mr. B. Pathak, who is present on behalf of the respondent, fairly submits that it is true that such direction would cause some sort of inconvenience to the appellants. The next paragraph. As such, in view of accordingly, it is provided that till the next date, the direction contained in para 10.3 shall not be given effect to, shall be kept in abeyance. And the matter is admitted for final consideration and hearing. Until next date. And hold it. Just after
3 weeks or 2
3
weeks.
weeks.
Yep, Your Lordship.
Item number 2.
Here was the report.
Yes, my lord, I have filed the report, my lord. Before I take your lordship to the report, your lordship kindly
It's
see
not,
the
it's not been
order
filed,
of the
Mr. Appeal General.
The
Lordship no indicates that in term order 27/8/2024, detailed report has not yet been filed.
No copies to me.
Yes, my lord, I'm sorry.
Then you give a copy to the petitioner also.
Yes, my lord. Before I take your lordship to the report, your lordship kindly see the order of Supreme Court. What is the issue? So then your lordship will place the report in perspective, my lord. Kindly see page 49 of the writ petition 281, my lord. 49.
Page 49.
49, 49, my lord.
Yeah.
First paragraph, my lord. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 1/11/2018 passed by the High Court of Meghalaya at Ceylon writ petition number 281 of 2017 and 360 of 2017. My lord, kindly mark these two writ petition 281 and 360 of 2017, by which Division Bench of High Court allowing the said writ petition has issued the following direction. The State of Meghalaya has preferred the present appeal, my lord. And in direction, my lord, of the Honorable Supreme Court on remand is at the last page, my lord, paragraph 12, at page 54. Paragraph 12.
Yes.
Matters are at page 54, my lord.
Yes.
The matters are remanded to the High Court to consider the grievance on behalf of the original writ petitioner with respect to non-implementation of Meghalaya Act 1969 and Provident Fund scheme under the aforesaid Act, if any. To that extent, it will be open for the original writ petitioner to amend the writ petition, to which it will be open to the state to file the counter. However, it is specifically made clear that remand shall be only to consider the implementation of Meghalaya Act 1969 and Provident Fund scheme thereunder, if any, only, and the High Court on the basis of pleading to consider which part of 1969 scheme framed under Meghalaya Act has not been complied with by the state, and or what extent same are not complied with. Only for the aforesaid purpose, the matter are remanded to the High Court. High Court to finally decide and dispose of the writ petition on remand within a period of 6 months from the date of receipt of the present order. So, my lord, after this, my lord, the parties agreed that this matter can be resolved, and your lordship recorded my that part. Your lordship will see in the order now of 281 at 22/3/2024, my lord, 28/2, my lord, 28/2 order of this court, my lord. That is 28/2/2023, my lord, up to writ petition 281 and 360, my lord.
28/2/2024.
28 February 2023, my lord. 28/2/2023, my lord.
28.
After remand, my lord, the matter came before your lordship. 2023.
28/2/2023. Very good. Right. The
The
state
state says,
says
my
that
lord, we consider to make every endeavor to resolve the matter and seek fortnight time in such regard. Let the matter appear after 3 weeks, my lord. And the next order your lordship will see at page 22/3/2023.
yeah.
Some middle ground may have already been found, and the state submit that it is in the process of preparing a scheme which would be acceptable to the petitioner association. On behalf of the association, it is submitted that notification of any scheme would by itself cover sufficient ground, and but the major issue will be even that teachers who have been serving for a long time may lose out. Association suggests that a draft scheme is prepared by the state and forwarded to the association, and association may put its inputs, which is acceptable to the state, my lord. Since the state already readily accepted the suggestion, state is requested to ensure that draft scheme is made over to the advocate or petitioner within 4 weeks from the date, and whereupon his association will date. Ultimately, my lord, this everything resulted in the process went on, and 27/1/2024 order, your lordship may kindly see 27/1/2024 2024 order. Sorry, 27/1/2023, I missed out that order, my lord. That order is also important. 27/1/2023.
But you've gone ahead of that.
Yes, I'm sorry, my lord. This is the lordship has recorded in 27 January order that it is on limited remand, my lord. Kindly see 5-2. I will not bother your lordship with that previous order. The subsequent order 5/2/2024, my lord.
5/2/2024.
5/2/2024 order. Yes, my lord.
Yeah.
Your lordship will notice that writ petition number 281 and 360 both are where before the Honorable Supreme Court, and it has been remanded, my lord, to this court on limited issue, my lord. Paragraph 2. The learned counsel has submitted that the main grievance of petitioner association is with regard to non-implementation of provisions of Meghalaya non-government school and college employees centralized provident fund scheme 1969. However, grievance of the petitioner association is that respondent authorities have till date failed to maintain centralized provident fund in any scheduled bank as defined in Act of 1969. Under the relevant provision of Act, a scheduled bank is a nationalized bank that has entered into an agreement with the government to deal with the provident fund of aided educational institution in the state of Meghalaya. In the case involving parties herein, though the state government has asserted that the state of Meghalaya has implemented said Meghalaya non-government school and college implied fund scheme 1969 in letter and spirit, for which notification dated 29/5/2023 in this regard was brought out, there is no indication whatsoever that such agreement or memorandum of understanding was ever executed by state government with any nationalized bank. In fact, by said notification of 29th May 2023, the Meghalaya non-government school and college implied centralized provident was constituted, and consequently the bylaws of Central Pension and Provident Fund scheme in this regard was also approved by Board of Trustees. Such bylaws have not been registered till date. Situation as it stands today is that contribution of employer and subscriber is still being deposited in saving bank account, which is not in keeping with the relevant provisions of said 1969 Act. Learned Counsel has therefore submitted that if direction by this court be issued upon the respondent to create the centralized provident fund account in the nationalized bank, the grievance of the members of petitioner association would be alleviated. In response, Mr. Kumar, Learned Advocate General, submits that relevant prayers made by petitioner association have been duly complied with, in as much as notification 29th May 2023 has been issued, and the Board of Trustees have also been constituted at this point of time, may issue a direction to Board of Trustees to pursue the matter of exclusion of said agreement with nationalized bank for creation of centralized provident fund account. The court has given due consideration to the submissions made and perusal of additional affidavit filed by the state, respondent number 1 and the rejoinder to the same by the petitioner association. What is understood that by notification of 29th 2023, centralized provident fund for all non-government school and college in Meghalaya have been constituted, for which contribution by employer applied to the set for such fund be maintained. A centralized provident fund account is required to be created in nationalized bank. Admittedly, said bank have yet not been opened till date. Under circumstances, court hereby directs the state government or Board of Trustees or any other appropriate authority to immediately embark upon the exercise to create said centralized provident fund account in nationalized bank by executing required MOU. Thereafter, said MOU to be operational, the exercise to be completed in 2 months. Now, in this light, my lord, but your lordship will see next part also. List this matter on 8/4. As far as writ petition 60 is concerned, Mr. R. Majumdar, Learned Counsel for Petitioner Association, has submitted the counter affidavit file has been received. However, it prays for rejoinder affidavit response may be allowed. Ms. P. Bhattacharya also 6 times. My lord, today 360 is not listed. My lord, both 280 and 360, both are relating to one common issue, implementation of the implies provident fund scheme, my lord. Now,
what is the report about? Okay,
my lord, which I
okay,
have
Mr. Advocate General. See, this is
report is that
come fresh before.
Bank account has been opened, my lord.
Yes. Detailed report.
Yes, the lordship will see page 5 of. Now we are,
Page 3, my lord. What was the order of 5-2? I'm just interrupting, my lord, if I'm not.
Yes.
5-2 order says that there is a clear direction, memorandum of understanding to be done, the account be opened. Lordship will have page 3 of today's report. Exactly that has not been done. And 360 disposed of, they were required to make an employee provident fund. That case is done separately. This 280, yes. They are required to now comply with the Employees Provident Fund Act and rules. That is a total separate issue. Here, Order 5 to 24 says the exact.
My friend,
Yes, yes.
please allow me to place my report. Then thereafter you may object to it.
Yes, okay. What do you see in your report?
Page 5, you also will see that, kindly see page 5. In exercise of power laid down in subsection 3 of Meghalaya Non-Government School and College Implies Centralized Provident Fund Scheme, government is pleased to constitute a fund called Meghalaya Non-Government School and College Implies Central Provident Fund for all non-government schools, etc. and appointed. So fund has been created on 29th May 2023, my lord. In terms of the Supreme Court order, that grievance we have already satisfied. Now, my lord, kindly see the second, the trustees, Board of Trustees at page 7, my lord. Which fund is to be managed by Board of Trustees, my lord, at page 7. That is 16 June, where it is expedient to make provisions the manner of investment of whole or any portion of fund in the government securities or otherwise. Board of Trustees and consider retirement and other benefits of subscribers of the employees of deputy schools and college with the approval of government. Now, the government in exercise of power under 4.1 of the Act is pleased to constitute Board of Trustees to frame, control, administer a centralized provident fund for employees of deputy schools and colleges to be called Meghalaya non-government so and so. So these are the Board of Trustees, my lord, which includes the representative from the petitioner association.
So your submission that sum and substance, the order was, so Mr. Amit Kumar, that means sum and substance, your submission is that.
Yes, my lord.
Supreme has been complied with.
Yes, my lord.
But then
yes, my lord. Supreme Court order has been now.
The petitioner has some
second stage, my lord.
Yes.
And there are some other grievances also which I must address also, my lord. Now, what has happened, that first part is that 1969 Act has been given effect to. Now, Board of Trustees are implementing the scheme on the ground, my lord, for which there are certain steps we are being taken by the Board of Trustees, which you will also will find at page 10. Grievance, second grievance, my lord, page 10 of the report, my lord, where the meetings have been held time to time by the Board of Trustees, page 10, my lord. These are the, I will not bother your lordship with the minutes of the meeting, but the steps which have been taken, your lordship will see at page 14 onwards, my lord. Page 14, Annexure 6, State Bank of India. Offer to open a current account for Meghalaya. So this is the offer given by SBI, my lord. Then various requirements have been listed out in the offer of the bank, that these are the requirements you have to, the trustees have to meet, not the government, my lord. Now Board of Trustees are running the, then there is a requirement laid down at 16, my lord. Then, so all these steps, my lord, have been indicated and for which you
we'll do one thing,
now,
we'll do one thing,
come back to the,
let them examine it, and where the shortcomings that they feel that order Supreme Court will comply with, you flag it, and we'll hear it next year.
I'll just point out, my lord, the order which was passed in on the last date, my lord. The orders of this court was what has been done after June 2024. Whatever has been stated today by the learned AG, these were all taken into account on the 5th of February 2024 orders. The order which was read out. Everything was taken into account. And then this Honorable Court passed an order that you do the MOU, you open the CPF account. Everything closes. Thereafter, it will be the Board of Trustees who need to do everything. In June, there was an order, whatever has been done after 24th of June 2024, that will be brought on record by the government. Now, on the last occasion on August, it was not brought on. Today, this report which has been brought on, Lordship will find at page 3, what has not been done. If I'm allowed, my lord, I'll read the 5-2 order again, what was required to be done. And let us see what has not been done at page 3. Every document submitted here is prior to 24th of June 2024. So therefore, that order is violated. Nothing after 24th of June 2024 is brought on record. Whatever was done prior to that. Now at page 3, para 12. After the government accords approval, the following steps are to be taken. So the government has not accorded the approval. That is not with the Board of Trustees. That is something to be done by the government, not done. Signing of MOU between Board of Trustees and State Bank of India, that would come after the approval. The approval has not come. Opening of Centralized Provident Fund account at SBI. This was the exact order of 5/2/2024. Not done till date. Acceptance letter by the state government. No statement made that there is an acceptance by the state government today. Therefore, the fund is not coming into existence as of today. Copy of MOU by the director, DHT and manager. Director, higher education, higher and technical education is a government person. Nothing done. Notification of the state government, that is there. Copy of the trust list, we don't have it. Copy of the PAN, they say they've got a PAN number, now they've applied for it. Copy of the resolution from the meeting of the Board of Trustees for authorized signatory, nothing on record till now. Letter of authorized signatories, we do not know whether it has come. Address proof, we do not know. KYC of signators, GST certificate, and application for opening the centralized provident fund. Lordship will see when it is said that the government has done it and the Board of Trustees are unable to do it. For the first letter of paragraph 2 will say, government has not approved the memorandum of understanding, government has not given the authority letter.
Yes.
From February till now.
Yes, and we get it.
Nothing has been done.
Mr.
Still hanging. And the order was, tell us what you did after June 2024. That is not on record, not a single document after June 2024. That is the apprehension. Otherwise, what was given by the Supreme Court, what was done, everything discussed in 5/2/2024 order. Everything was done. It boiled down to the fact that we need a CPF account where we will be subscribers. That is what it boiled down to. 360, we said CPF is not applicable, government said CPF is not applicable, Employees Provident Fund is applicable now. Two orders have not been answered, 5/2 and the last of June. What happened after June? Only those two.
I will answer, Your Lordship, kindly see paragraph 8, my lord. Paragraph 8. 8 at page 2, my lord. My friend has finished. The offer letter from State Bank, Lai Mukra, Shillong, dated 28th May, was received by the Secretary to the Government of Meghalaya for opening current account for centralized fund scheme. Then
So you mean to say one thing is not it is not a report that shows full compliance. It's just a report showing the progress. You mean to say that the progress? So how much time will it take to? You see, they ordered 5/2. If I correctly can read it, is that they wanted a direction from this court to create the centralized provident fund account.
Yes, Lord, that is what
correct. And so has that been done or not? As simple as that.
Yes, my lord, so kindly see, but three steps are required, which are enumerated in paragraph 9.
No, so you mean to say that it's just a status report, it's not a final report.
It's not a final report. That is
yes,
correct.
Then when are you going to complete the entire exercise?
That is what I want to show you, Lord. So the steps which are required, because this
exactly
is
okay, fine. We will accept your contention that it's only the steps that have been taken, you know, to ensure compliance with the whatever 5/2 orders, the other orders, and Supreme Court directions. Correct.
Yes.
Yes.
So
how much longer will you take?
Because the entire issue, Your Lordship, because the order of the Honorable Supreme Court has been complied, Your Lordship direct the Board of Trustees and government to complete the exercise within a period of 3 months, failing which if the exercise is not carried out, they can dispose of the matter because the
we'll keep it open. We'll keep it open. We'll record objections with Mr. Mazumdar and we'll keep the matter open. We'll list it again after. When can you complete exercise?
Three things, exercises which I wanted to show, my lord. What are the exercises which are going on? My friend is brushing aside those exercises. Kindly see the page 5, paragraph 9, 10 and 11, because 10 and 11, these are the exercises which are required.
No, Mr. Let's not lengthen the the discourse. Let's not lengthen the discourse. We'll come down to the brass tacks is that you are in the progress of complying with the orders. That's all.
Yes, sir. Yes, ma'am.
That's it. Creation of this centralized provident fund account. That's not been done.
My friend is saying that nothing is happening on the ground is not.
No, it's not saying nothing is happening. Okay, fine. We'll record. A report dated 5/9/2024 has been placed before the court on behalf of the respondents, which is stated to be in compliance with the order dated 30/5/2024 passed by this court. Stop. The Learned Advocate General, who are relying on the same, has submitted that substantial compliance has been effected and substantial compliance, and that whatever has been directed has been put in place. Stop. Next para, Ms. Arnaldar appearing for the petitioner. has however raised strong objections to the contents thereof, especially at para 12, which he submits that necessary approvals yet to be obtained from the government for such as for signing of the MOU and for opening of centralized provident fund account at SBI. So, to this, Little Archangels then retracts its submission, has submitted that the report, in fact, is to show the progress made in compliance with the orders of this court. Next paragraph. In consideration thereof, as it is submitted that the progress is on, it is expected that the entire exercise be completed within a period of 1 month from today. This is the matter after 4 weeks for compliance.
Milord, one more thing, Mr. Milord. The other writ petition has been detagged from this one because both are from this judgment common.
It's been disposed, I believe. That's what the submission. No, you'll find out.
My impression is
mention.
Let it be.
Lordship, the other writ petition is disposed of, and
Yes.
with the
That's what I'm saying.
Yeah, Lordship,
Bring the
with the
order on
direction-
record next day.
I'll get the order on the next.
That's correct.
Copy of the writ taken on board with passport.
I'm obliged. ma'am.
Item number 3.
Obliged, Lordship.
Obliged.
Please, my lord.
My lord, I want to place some documents before this.
One second, what's the matter about?
This is a customs appeal, my lord, against the order passed by state. This is a case of gold seizure.
Yes, my lord, before going into the merit of the case, I am challenging this appeal basically on the ground of maintainability, my lord. Kindly have a look on the.
One second. For hearing, no orders. Yes. Yes.
Yes, my lord, kindly peruse the page number 1, my lord. My lord, these were the initial instruction issued by the Department of Revenue, my lord, and it was on the basis of the reduction of government litigation, providing monetary limits for filing appeals by the department before CSTAT and High Courts. And all these things were gathered, and my lord may kindly have the page number 3, my lord, wherein they have issued the notification for the same, my lord. Subject is reduction of government litigation, providing monetary limits for filing appeals by the department before CSTAT, High Court, and Supreme Court also, my lord. In exercise of the powers conferred by the Section 35R of the Central Excise Act 1944, made applicable to the service tax wide Section 83 of the Finance Act 1994 and Section 131BA of the Custom Act, my lord. It is specifically mentioned here, it is the under Custom Act also. The CBIC fixes the following monetary limits below which appeal shall not be filed.
What is this? Excuse me, see my brother's copy you've given, its pagination is upside down, even the pages are stapled upside down. You kindly correct it before we take up the matter.
My lord, my lord. We have extra copy also, my lord.
At least should make an endeavor to ensure that the copy handed over is in correct form.
I'm sorry for that, man.
Yes.
Yes.
Page 3 is saying.
Page 3, man.
So your case that about 10 lakhs, under 10 lakhs, no appeal should be preferred.
No, my lord. My actually the limit has been again enhanced. Kindly have a page number 4, my lord. For High Court, it is now 1 crore, my lord, at present.
Okay.
So the goods seized were amount of 1 crore 67 lakh rupees, my lord. So earlier they could file the appeal, there is no problem. But now it is 1 crore and the goods seized were 1 crore and 67 lakh, on which the duty is 16%, my lord.
that come around 20-21 lakhs rupees only. So my humble submission is, my lord, that due to this monetary ceiling which has been set by the government, this appeal is not maintainable before this court.
Okay, answer yes. Dr. Mozika.
My lord, this is the first time this is raised, my lord, so I'll require instruction. But otherwise also, my lord, the matter is listed after quite some time.
My lord, it is 3-4 times they have taken the adjournment, and I have come from the Chandigarh altogether, my lord.
We give equal treatment to all counsels, whether he comes from outside the court or he
my
comes
lord,
from.
My lord, every time they are taking the adjournment, my lord. It is my humble submission. Since filing of this.
Since order today, we'll fix a date. You come, we'll finish it up the next day. Yes, sir. An objection has been raised as to maintainability of the present appeal on the ground that, as per the policy decision which has been notified by notification dated 2/11/2023, the monetary limits for which appeal shall not be filed has been prescribed. Like Dr. M. Mozika, counsel for the appellant, Leonard Senior Counsel appearing for the appellant, submits as this is the first time.
My lord, the appeal was filed subsequently to issuance of this.
This is the
circular,
first instance that this objection has been raised. He please allowed some time to examine the matter and to. When?
After 3 weeks, 4 weeks.
Leave the matter for
my lord, 4 weeks is too much. 2 weeks, my lord, is enough.
After 3 weeks.
Obliged, my lord.
Item number 4.
Yes, Mr. Dharma. You didn't take steps. Then the office note says Taliban has not been filed.
We have received copies on behalf of respondent. I'll be entering appearance, my lord.
You're only one respondent?
So respondent, my lord.
Okay.
2 weeks time.
What kind of steps did you take then? Not go to office?
I have taken this from the DJ directly because last week it was directly from the office because it is to be given dusty service also.
A private was permitted, right? Mr. W. Jorwas entered appearance today on behalf of the sole respondent. As such, service of notice is complete. This is the writ petition or writ appeal? This is a matter after permission hearing.
Time may be given, my lord, to file and show cause to the condemnation application 3 weeks time.
Or is the delay?
Delay.
Yes, he prays for allowed. How much time?
3 weeks time, my lord.
3 weeks time to file objections to the application for condemnation of delay. List accordingly.
Obliged, my lord.
Any mention?
My lord, I beg to mention item 23, my lord.
Number?
23.
Yes, Isotun.
Yes, my lord.
Who's for the other side?
My seniors here.
Any objection?
No objection, this will become infructuous within due time.
So when will it become fructuous? So we'll after that.
It will be 2 weeks, no issue.
By 2 weeks it will be fructuous.
It will become, is right now infructuous also, but we will not come to that.
On the prayer also, this matter of 3 weeks, yes.
Deeply obliged, my lord.
May it please your lordship. Lordship, I beg to mention item number 26.
20?
26, my lord.
Yes.
And for the respondent number 6, MTTC, we are still awaiting instructions in this matter.
We have not received.
How much time? 2 weeks?
2 weeks time, my lord.
2 weeks request of counsel number 6. Yes.
Please, your lordship. Lordship, I beg to mention item number 27.
27.
Kindly grant 2 weeks time, your lordship.
I'm appearing for respondent number 7, lordship.
Who's for the petitioner?
I'm for the
For the petitioner. How long?
2 weeks, your lordship.
Any urgency?
No, your lordship.
3 weeks, yes.
Stay order is there. Yeah, stay order is there, your lordship. The stay order is there.
Zero is there in 2 weeks, yes.
1 week, lordship.
1 week. Now you're running from behind. Why?
27. Item number 2, add for the.
You have objection to the adjournment today?
Pardon?
You have objection to adjournment today?
Let it be after 1 week, lordship, because
Yes,
the interim.
the prayer will meet for 2 weeks adjournment on objection of Mr. S.K.S. Sheikh. This is matter up to 1 week, yes. Interim order, everything shall continue till next date. Yes.
Supplementary list, item number 1.
May I please, your lordship? Your lordship, the petitioner here, he has inherited landed property measuring about. Your lordship?
Who is the petitioner?
The petitioner, he has inherited some landed property from his late father, and after that, your lordship, an issue was accordingly, pata was accordingly issued to him, dated 14/10/2016, lordship, which is at Annexure 2.
Okay,
However, lordship, the land of the petitioner has been encroached by some adjacent landowners, and the petitioner, having no alternate remedy, he has filed an application to the Assistant Settlement Officer dated 29/7/21, which is at Annexure 4, lordship, with a prayer to for demarcation of his land. And thereafter, lordship, the Assistant Settlement Officer, white order dated 1/12/2021, he has directed the chainman to demarcate the land of the petitioner. And in pursuance of that direction, lordship, the chainman, he has submitted the report for the demarcation dated 29/1/2022, which is at page 29, lordship, Annexure 6. However, lordship, in the survey report, the chairman, he has surveyed the land bearing pata number 19, dark number 52, which is not the land of the petitioner, lordship. And being in brief, lordship, the petitioner has again approached the revenue officer, and the revenue officer, in turn, he has issued an order dated 12/3/2024, directed the survey Kanun Co and chairman to cause detailed inquiry and verification of the land of the petitioner. But no spot inquiry has been conducted on that date, and fixed another date, and lordship, and subsequently, the revenue officer has again issued another direction dated 25/5/2024.
22/5 or 25/5?
22/5, lordship, Annexure 8. with a direction to cause spot inquiry and verification for demarcation of the land of the petitioner. However, Lordship, on that date also no verification has been done. So I humbly pray before this Honorable Court, Lordship, that direction may be given to the respondent authority to demarcate and cause for inquiry and verification of the land of the petitioner.
Yes.
Your Lordship, I'll obtain the instruction, Your Lordship.
When?
1 week, Your Lordship.
1 week. Yes, heard MSD Mortal Consultation issue notice. You have not made the private respondent who encroach into your land party in this proceeding?
No, Lordship.
Why?
Lordship, because the authority to demarcate is...
Of course, but even then, if they have encroached, yes. Anyway, heard MS, that is your call, MSD Mortal Counsel Petitioner. MSN Raji.
2 weeks, Your Lordship.
Vice, Mr. SD is present, except we have all the response, no further notice called for. Stop, I just submitted that the matter relates to the prayer for demarcation of the petitioner's land, who stated we have got the holder, but in spite of orders being issued by the respondent number 3, but demarcation till date has not been carried out. Stop. MSN Raji undertakes to obtain instructions before the next day. Just after 2 weeks. Yes.
Highly obliged, Lordship.
Item number 2.
He is here.
Yes. You've done some research.
Yes, Lordship.
Maintainable.
It's not maintainable, Your Lordship.
Maintainable.
Your Lordship.
So we will withdraw availability to file before the proper forum.
Yes. There's a Khanongbak Senate Council purchase praise that he may be allowed to, on a question, please be allowed to withdraw the intervention with liberty to approach the appropriate forum. Prayers allowed with liberty as prayed. Matter stands closed.
Daily list, item number 1.
Please, Your Lordship.
Yes.
Your Lordship, the private respondent that are yet to file their affidavit, Your Lordship.
Please, Your Lordship. Lordship, I'm appealing on behalf of the private respondents, Your Lordship. Lordship, I plead for a week's time, Lordship.
Why?
Your Lordship, as we are representing 9 respondents, Your Lordship, we need to get all of the details, Your Lordship.
How many times have you prayed for time?
This will be up to
Do you end time?
Lordship, for the serious respondents, we've already filed our affidavit.
You filed it on 21st.
21st, Lordship.
Today, again, prayer has been made on behalf of the respondents 6 to 10 and 15 to 18 for further time to file affidavit. So, it is noted that repeated time, no repeated apologies have been granted in place of justice for the 3 weeks time granted. Stuff. Mr. H. Karan Lang, Aristide submits that on behalf of respondents 1 to 5, the affidavit has been filed. Just after 3 weeks, you'll find rejoinder to affidavit filed by the state respondents.
Your Lordship, we are here to receive instruction with regards to rejoinder.
This after 3 weeks. 3 weeks, make sure affidavit on board.
Yes, Lordship.
Yeah.
Item number 2.
Yes.
Lordship, very limited issues involved in this case. This is regarding a suit. I am a defendant petitioner before this honorable court.
Yes.
So the plaintiff respondent, they had filed a suit.
You?
The plaintiff,
yes.
The respondent, plaintiff before the trial court filed a suit. As defendant, we entered appearance. So the issue involved His Lordship that after the written statement, we filed an application under Order 14 Rule 1, saying that to hear on the issue of limitation. Admittedly, the only legal issue involved is, Your Lordship, Section 14 of the Limitation Act. And Section 14 of the Limitation Act, Your Lordship, gives immunity that if you are pursuing this matter
somewhere else,
in a wrong forum, So the language very clearly says, Your Lordship, if the court in which you were pursuing the matter, it didn't have a jurisdiction, and a bona fide mistake was that when you come to the right forum, you get an immunity. So issue this, Lordship, we file an application saying that it's barred by limitation, and they file a reply to our application. The very important pleading is this, Lordship, in the application to our order 14, they have not pleaded that they were pursuing the matter in some other court. That's an admitted fact.
In the trial court.
In the trial court. So
Right.
their reply is this before this court, Lordship. They have never pleaded that they have approached this court because some other matter, the same subject matter was pending and it was in a wrong forum. So they have withdrawn that and they have approached. If that pleading was there, Your Lordship, then the issue becomes very, very, very narrow.
Yes.
Now, Your Lordship, just come to page 148, the impugn order. 148 of the writ petition, Your Lordship.
Yes.
So, Lordship, is an admitted position that they have not pleaded that it was wrong jurisdiction. Lordship, the wording is at first paragraph itself that without going, Lordship has got it. 148. That without going into the merits or demerits of why the instant suit was dismissed on default, the court is of the view that since the opposite party plaintiff has executed these civil proceedings in due diligence in the appropriate forums having no jurisdiction. So I'm emphasizing on the word no jurisdiction. It is not the pleaded case. The time taken in executing the civil proceedings shall be excluded from final computation of the limitation for a period by virtue of section 14 of the Limitation Act. This finding of the trial court, Your Lordship, that they were following the case, it had no jurisdiction.
No, but why is the recorded here dismissed on default for default?
That is some other matter, Your Lordship. That is not, in fact, it is recording some other matter which was pending.
Without going to merits, why instance suit is dismissed on default? For default, what they said.
This is regarding some other matter, Your Lordship. Lordship will just come up to the previous page, the last paragraph.
Why some other matter? Why is it recorded here in this order?
No, it was 145 proceeding, Your Lordship. That is exactly the point. To Your Lordship, I'll come to answer that, Your Lordship. To answer that, if I may just take, Your Lordship, to the reply they have given to a petition, which is 139.
The application.
My application, my application, Your Lordship,
Application, where is it?
my application is at page 136, Your Lordship.
Okay, what do you say in application?
The relevant paragraph is para 3, page 136.
Okay.
So that the issue of limitation, whether the suit is barred by law of limitation, can be decided first as preliminary issue under Order 14, Rule 2, before settlement of the issue. And Your Lordship, the objection is at page, therefore I reply at page 139.
Yeah.
Lordship, the specific reply that they're given is, Your Lordship, at page para 6 and 7. Para 6, Your Lordship, this is the allegation here in para 1 are totally baseless and vindicated as denied. The instant suit is not barred under law in the manner. Further, the provision of section 14 of the Indian Limitation Act itself provides that whenever there is any legal proceedings is pending for bona fide judicial determination, in that case, the said period is excluded for the purpose of determination of the period of limitation. As such, the alleged bar of limitation in any manner does not attract in the instant suit. Now we come to para 7, Your Lordship. That the allegation in para 2 are totally baseless is because the instant suit was, there are no joinder of cause of action and it is permissible under law. As such, 2001 is not the starting point of limitation of instant suit. It is not mentioned herein that the miscase number so and so and under section 145 of CRPC was.
They have said they've taken the ground. You said they've not taken the ground.
No, Lordship, they have not taken the ground that all these matters were pending before a forum.
That it has to be mentioned here that the miscase so and so the issue of good faith and subsequent continued and pending till date instant suit.
No, Lordship, the important issue is this, that suit is still pending.
Suit still pending?
This petition under 145 is still pending.
Okay. They have not withdrawn. They have
They have not withdrawn. That is, Lordship, is slightly, the facts I just have come to the main issue involved. Had they withdrawn it, or had they closed all the other proceedings, Your Lordship, and they would have come here. And they could all the number of years, 5 years, 10 years, 15
So
years.
cause of action arose when?
No, 2001, Your Lordship.
And they filed a suit when?
2019.
19.
More than 12 years, Your Lordship. And Lordship, and so Lordship, para 6 and 7, it is not the case that they have opposed the civil court. Civil court will have jurisdiction because they were bona fidely pursuing the matter there, and they have withdrawn from there. The cause of action survives. They are still saying the matter is still pending there, and there is no admitted pleading. That
Okay.
now, Your Lordship, if their case, and this is para 6, 7, 8, and Your Lordship will see 9, 7, 9, 10, 11. It's an admitted case in the objection. Now if you come back to the finding of the court, Your Lordship, again at page 140 of the paragraph, page 48, 148, Lordship.
Read from 147 last.
Lordship, yes. Okay, Lordship.
That will bear proof of case.
Absolutely, Lordship. The same thing, Lordship, which I read.
You can read it, so I help the court to understand.
That on the bare perusal of the case record, it appears that on the year 2001, when the cause of action arose, the suit premised by Miss Case number so-and-so under section 145 CRPC was kept under attachment by an order dated 13/11/2001. Thereafter, 2001, the opposite party in the year 2002 filed an appeal before the Court of Learned, Court of Additional District Magistrate, White Civil Appeal number 4 of 2002. Thereafter, the appeal was dismissed on default on so-and-so. The opposite parties later approached the Revenue Appellate Court of GTC that the matter was kept pending there for quite some time with no order passed, disposing of the case in default in 23 March 2017. Now, it's an admitted fact, Your Lordship, that dismiss in default means the list reached its conclusion. It was not withdrawn.
Yes.
It was not withdrawn. It reached its conclusion and it was dismissed on default. The case would have been different if the matter was pending, they would have withdrawn it. Very important issue, Lordship, here is this: if they would have withdrawn it, then the whole issue would have been whether the section 14 will be applicable or not. It reached its logical conclusion and met its natural fate. Now, after that, Your Lordship, what is the finding of this court? This next paragraph, paragraph 148. That without going into the merits and demerits of why the instance was dismissed on default, that is not the subject matter of section 14 itself. This court is of the view that since the opposite party has executed the civil proceedings in due diligence in the appropriate forum, having no jurisdiction.
Yes.
So the trial court, Your Lordship, assumes its own opinion that it's no matter it was default, but it had no jurisdiction. Then, Your Lordship, the time taken in executing the civil proceedings shall be excluded from the final computation or limitation period by virtue of section 14 of the limitation. Though it was dismissed by default, it was not withdrawn, but the trial court, and there is no specific reply to that in the objection petition, no pleading that it had no jurisdiction, no pleading that the list was pending and they withdrew it. So this finding, Your Lordship, is highly perverse, not based on facts. We are only on this limited ground, Your Lordship.
Yes, Nandi.
If this honorable court can set aside and remand the matter back, we are only asking for that.
My lord, so far as this present case is concerned, what is their petition before this? And what is the ground they have set up? Their petition before the learned trial court is that the defendant number 11 has submitted that 13 numbers of draft issues, including the issues whether the suit is barred by limitation.
Yeah.
That cause of action for the suit arose in the year 2001, which is the starting point of limitation as to the instant suit available in the averments of the plaintiff itself. That the issue of limitation, whether the suit is barred by law of limitation, can be decided first as a preliminary issue under Order 14, Rule 2, Sub-Rule 2, before settlement of all other issues. That the starting point of the limitation was admitted by the plaintiff itself. That in this case, the limitation is pure question of law and it can be decided as a preliminary issue under Order 14, Rule 2. In view of the circumstances, the issue of whether the suit is barred by law of limitation may be decided as a preliminary issue.
Yeah.
Now, what is their ground? We have filed our written objection. The written objection is part of this record. In the written objection, my lord, we have categorically stated that cause of action is the bundle of facts and it has got the relevancy and the entire plaint is to be read out. And in the plaint, it is categorically mentioned that the first, when the suit plot of land was kept under attachment, thereafter the present respondent, the petitioner say, they filed, the defendant side, they filed an appeal. And in the appeal in 2013, it was dismissed. Thereafter, again, the matter was went before the district council. And district council in the matter, the pending before the district council has decided that matter. And thereafter, the original 145 proceeding that is untraced. Yes, that is untraced. And then we have come up, because in 2009, it is categorically mentioned that 2009 and 10, the present defendant number 1, he has constructed the house where there is an attachment order is there. Now, for the purpose of the cause of action, my lord, the order 14 rule 2 is very specific. Any application is pending, and if that application is decided or the time taken for the decision of that application or the application is pending, their civil suit cannot be brought. And under these circumstances, what is their ground, my lord? Their ground itself says that there is no ground to interfere with the impugned order. My lord, kindly peruse the ground number 3 at page number 8. What is their submission in this ground is that for that the learned trial could add in both law and facts in as much as the question of limitation is a mixed question of law and facts. If it is a mixed question of law and facts, how there can be ground of law? Issue on law can be decided. They themselves have stated that the question of limitation is a mixed question of law and facts, and in the instant case it is incumbent upon the learned trial court to frame preliminary issue on limitation and, if needed, should have allowed the parties to adduce evidence for adjudication on law and facts is made. The same not being done, the learned trial court has learned trial court, and as such the impugned order dated suffers from serious illegality and infirmity. How, my lord? They wanted to frame a preliminary issue on law. Their ground itself says that the issue of limitation cannot be decided as a law, as an issue of law. It has to be recorded by evidences. Then where is the wrong committed? And they have said that the ground, the other ground that they have taken here is that the civil proceeding, my lord, 145 case, it is a quasi-civil proceeding. So in the quasi-civil proceeding, if the time has been taken, that cannot divert the plaintiff to come up before this learned court. He was fighting for...
No, his only submission is this. Notwithstanding any proceedings which which you had put up before any other court over proceeding or close, that fact was never brought in objection to say that, or that those proceedings were closed by you before, and coming with a clear statement before the civil court saying that those proceedings, they should lapse now, and that the time taken to pursue this should be excluded from the computation limitation. I'll come with my civil suit.
My lord.
That is his only case.
My lord.
Yes. If he says that the whole thing is mixed up because mixed question law 5, because whether that's 145 matters pending, whether those suits have been, or these proceedings have been dismissed for default, what's happening, nothing appears from the order. Correct? So that is what. So here's what you have to say.
My lord, so far as this case is, now what is the order 14 rule 2 says, as they have come up. Now order 14 rule 2 says, order 14 rule 2, my lord, where a hearing for a summary judgment is fixed, the respondent must, Order 14 rule 2, where issue of both law and and of fact arises in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only, it may try that issue first, as if that issue relates to the jurisdiction of the court, a bar to the suit created by any law for the time being in force, and for that purpose may, if it necessary fit, the postpone the settlement of other issues until after that issue has been determined, and may deal with the suit in accordance with the decision of this issue. That means, my lord, here it concerns only relates to the issue on law. And how the question of limitation they have raised, it can come as an issue of law. And in this regard, my lord.
See, if you want to know the mind of the court, the thing is like this. Now, they have asked for determination of preliminary issue on a question of limitation. Now, even the court's confused with regard to, and has brought things, has drawn, saying that the proceedings are there by section 14. Now, the thing is that if the court is clear, now you want to apply order 14, order 14 rule 2, then the parameters must be very clear. The pleadings must be very clear also.
My lord.
Yes. And in this case, correct, what in the ground also they admitted that is a mixture. So there's no question of it being decided preliminary issue. Let it be decided together with the entire suit.
Then that can be decided along with the suit.
So that's the only thing, Mr. Khan. You see, it's all mixed up. The order, you can't interpret it really. Where has the what findings been arrived at by the trial court? He's just drawn his own finding from whatever understanding that the court might have. And yes, maybe you might have, but that'll be it'll be framed as one of the issues. So you cannot be taken separately as an issue. That's observation of the court.
Absolutely agree with you, Lordship.
Yeah.
Lordship, for a moment, can we just read the 14
Limitation Act.
Lordship, I have an extra copy.
See, that's going to hyper-technicality.
No, I'm not, Lordship, I'm not happy. I just try to reply. How is the impugn order wrong, Lordship? What is found from a court, Lordship, eventually, if my order 14, 1 and 2 fails, it will go to that level. But at this moment, Lordship, how we agree? Because there's a purpose finding by the trial court. It has assumed an issue of law which is not pleaded, only on the issue of order 14. Now, I agree with the submission of my learned friend that the issue of limitation is a question of mix of fact. He has not even gone to that part.
See, the thing is that section 14, it is a question of a party, proceeding in a court without jurisdiction bona fide.
Yes.
Correct. Now, these circumstances are very different. They were on 145 proceeding. Now the trial courts go into the circumstances of attachment. The other thing to be decided.
Yes.
Now, whether the court summarily their suit can be thrown out at the stage. No. That is what.
Lordship,
so if their matter deserves some adjudication, then
my only limited prayer, Lordship, is this, because it has assumed, Lordship, this honorable court may interfere with this order, remand the matter back, and to decide the application under order 14 rule 1 on merit. If it's a question,
that'll just prolong the suit unnecessarily.
No, Lordship, a fixed time will be given, within fixed time.
My lord, this very law and facts, once their ground itself is that it is an issue of law and facts.
Ground may not be the
why they
ground may not
separate?
It's not sufficient as the pleadings made in the plea.
And Lordship, trial court itself says we don't go into the merit. It has not even touched the merit. We have deprived on the issue.
Then it needs to be recorded, my lord. In the suit itself, it covers everything. The suit, there has to be evidence.
No, because it's not even a question of section 14, Mr. Khan.
Lordship, allow me to just...
Because you see, section 14 is very clear. It's really that suppose you pursue a remedy before a court bona fide.
Yes.
It's not that you're putting
Lordship, if you allow me
to appeal any other kind of orders.
Lordship, if you just allow this is two very important words in section 14. Lordship is very correct. It says
bona fide.
Bona fide, which from difficult jurisdiction, Lordship. That word, I'm only into that. Lordship, just allow me to just the other level explain, Lordship. In computing the period of limitation of any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceedings
whether in a court of first instance or appeal or revision, against the defendant shall be excluded where the proceedings relates to same matter in issue and is prosecuted in good faith in court, which from defect of jurisdiction or other cause of like nature is unable to entertain it. So defect of jurisdiction and unable to entertain it.
Exactly.
Lordship.
That's what the court is saying. That whether Section 14 comes in at all.
Lordship, I was not even given. I was not
that your objection is on a totally different, what do you call it, footing altogether.
Lordship.
Now, by drawing in Section 14, how Section 14 is drawn in? This court doesn't understand how it's been brought in.
Yes.
It's a question of them pursuing a remedy bona fide. They were pursuing bona fide a relief which is available under 145, the quasi, a civil proceeding. If what other attachment are there, that's to be gone into. But we're not going there. But the thing is that if a suit to be tried, it has to be tried on, it has to be adjudicated completely.
Slightly, Lordship, a grey area.
It's not a question of being a summary trial that, that yes, it's very clear. This is, black and white. A suit's been brought, it's, it's barred by law or it has other defects, which can, then it goes under Order 14.
If you see the objection of the plaintiff, I have read of the objection clearly, Lordship. They have not even pleaded that all those proceedings.
Forget about the objections. It is under 227.
Lordship, yes.
Then we'll correct the procedure as well.
Absolutely. My limited knowledge is, Lordship, let them interfere and let the application be heard on merit on an issue of limitation. If that application fails, Lordship, then I agree, Lordship, we'll go on the merit of all the issues.
My Lord,
only limited play.
If the issue of limitation itself is an issue, it will be obviously decided by the learned trial.
Yes. Mr. Nandi, see, it's under 227. This court only sitting supervisory jurisdiction. It just do some direct for course correction. That's all. Limited to that.
Only
one orders, yes.
Only limited.
We reserve them. Reserve. Yes.
Deeply.
Item number 3.
May it please, Lordship.
Yes, but we don't have, number 14.
May it please, Lordship. Respondent number 4 has filed their affidavit in reply today morning, Lordship, and we just received. But we require some time, Lordship, to peruse the same.
Who's respondent number 4?
I'm from respondent.
Your affidavit defective.
Yes, Your Lordship. Your Lordship, I have to annex my verification on the
Where have you annexed it?
Your Lordship, I couldn't annex today, Your Lordship.
Next to the order sheet? See.
By mistake, Your Lordship, I didn't annex my verification, Your Lordship.
It's not here. You correct the defect. Yes, opposite indicates that the affidavit find on the 4 is not in proper form as the verification is not present. MS also prays for once allowed. 1 week's time to correct the defect. Anything else?
This is the matter which is supposed to send to tribunal, Your Lordship. That he was for us that case.
Oh, that one that we said.
Yes, this is the case, Your Lordship. Boundary issues between the 4 villages. Deeply obliged.
Item number 4.
Make please, Your Lordships. Well, in this case, on last occasion, my Lord, RBI had filed their affidavit. So the pleadings on the part of the respondents are complete, my Lord. Lord, we'll be seeking 2 weeks' time to file a reply to, Lord, to all the respondents.
Wait, please. I am appearing on behalf of the RBI, respondent number 8, 9, and 10. We have filed our affidavit on the last statement.
Can file rejoinder? Mr. Dubey will file rejoinder to do.
Yes, Your Lordship.
Yes, my Lord.
So P. Hazarika submits that on the last date. The affidavit on behalf once in intent has been filed. Stop. Mr. Dubey, R. Dubey, for the please. How much time, Mr. Dubey?
2 weeks,
2 weeks.
2 weeks time, find rejoinder. List thereafter.
Your Lordship, interim may continue.
Interim order shall continue till next.
Item number 5.
Online.
Number 5 to 13 are connected, my lord. State has filed the affidavit.
Ready the matter today?
My lord, the private
Yeah,
respondent.
private respondents yet to file their affidavit, Your
No
Lordship.
private respondents.
Your Lordship.
Your Lordship.
Yes, that encroachment is
Who
allowed.
is the CM of Nongstoin, Your Lordship?
Yes.
CM of Nongstoin. Your Lordship, I'm representing on behalf of respondent number 5, Your Lordship.
See what I'm saying?
Yes, Your Lordship. Lordship, by tomorrow, Your Lordship will be filing our affidavit.
By tomorrow. Very good. Yes. When was the affidavit filed on behalf of the state?
My lord.
When was it filed on behalf of the state? When?
My lord, about a month back.
Month back. MS.A. Guru.
Your Lordship, Ki Guru.
Okay, Guru, sorry. A Pradhan and K Guru is mixed. MS K Guru on behalf of 105 submits that the affidavit on behalf of 105 we file tomorrow. You'll file rejoinder with
Yes, Your Lordship, will be filing the rejoinder.
to the affidavit filed with state respondents.
State respondent.
Yes, list after 2 weeks for further orders and for rejoinder to the affidavit filed with the state and for further orders. We'll dispose it of next day.
And
Yes.
14.
My lord, I'm inter-appearance on behalf of respondent number 4.
Number?
I'm inter-appearance on behalf of respondent number 4. 3 weeks time may be granted for filing an affidavit, my lord.
What about number 5?
Number 5, I have filed also.
They have already filed.
Your Lordship, state has also filed. We filed on behalf of respondent number 2, number 3, and 1 and 2, 3 will also rely on the same affidavit, Your Lordship.
Your
3
name?
weeks time may be granted, my lord, for
Your name?
filing an affidavit.
Your name? Your name?
A. Sangma, my lord.
A. Sangma.
Yes, my lord.
A. Sangma's inter-appearance on behalf of the respondent number 4 today, and as such, service is complete on the respondents. We pray for allowed 2 weeks time to file affidavit stuff. On behalf of respondents number?
Respondent number 4.
No, on behalf of number 2, MSZ Novelty submits that LRGA submits the affidavit has been filed and that the respondent 1 and 3 would rely on said affidavit.
Yes, Your Lordship.
You already filed also. When you filed?
Yeah, I have filed it last week. It is there in the report.
Yes. On behalf of number 5, which Sama submits
On
that
6th June
affidavit
2020.
will file. Yes. Just after 2 weeks.
Lordship.
For affidavit.
15. Obliged, Your Lordship.
15.
My lord, in this matter, we have received a notice from the High Court Legal Service Committee informing us that this matter has been referred to Lok Adalat on 14th September.
What's the matter about?
This is non-payment of salary, my lord, teacher's salary.
Okay, as that is reported that this matter has been referred to the National Lok Adalat.
Yes, my lord, National Lok Adalat.
On 14th September.
My lord, state authority has also received a notice, my lord.
Also, list this matter thereafter.
My lord, obliged.
Obliged.
16.
Oh, wait, any order. Yes.
Lordship, I already filed my affidavit yesterday, Your Lordship.
Number 7, who's appeal number 7?
We have completed this service, my lord.
Yes, but not received that yet. Who's number 7?
For respondent
Who's number 7? Whom?
I'm for state respondent 1 to 6.
Who's respondent number 7? Namaz?
Secretary, Your Lordship.
The Chairman Village Employment Council. Yes,
Chairman.
8, 9, no one appears.
7, 8, 9.
Yes, you file your affidavit.
Yes, Your Lordship.
You Mr. Pala.
Yes, Your Lordship.
Mr. Pala submits that this has been filed on behalf of the respondents number, respondents of 1 to 6 stuff. Office note, however, indicates that there was not complete on respondents number 7, 8, and 9. just after 2 weeks for service report. Petitioner also permitted to obtain status of service in the meanwhile. Yes.
Obliged.
17.
Please, Your Lordship.
May it please Your Lordship.
Yes.
Our Lordship,
Well, modality.
we file the affidavit, Your Lordship. If Lordship kindly see, Lordship, we filed it yesterday.
You received copy?
Yes, my lord.
You agreeable to the conditions?
Yes, my lord. The only thing, my lord,
If Lordship
One thing,
kindly,
let's see the
Oh, no.
if Lordship kindly come to
number 7.
Lordship kindly come to Annexure 2 at page 6.
Where's
Then-
the SOP?
Then Lordship, I'm taking straight away, Lordship, to page 10. SOP for running tourism facilities at Krangsuri Waterfall. Where the Lordship got in.
Yes.
May I read it, Your Lordship?
That's all right, yes.
Lordship.
Yeah, only patience with regard to the SOP.
my lord, this SOP was prepared in consultation with the petitioner. We are agreeable to the SOP prepared, my lord. But it's just that, my lord, if my lord can come to page 11,
Yes.
this paragraph 10.
Yeah.
My lord, here we have given them the personnels that are required, and they have reflected here that at the counter 2 staff is needed, lifeguard 4 staff is needed, parking lot 2 staff is needed, boatman 2 staff is needed, watchman 4 staff is needed. So we have placed before the state respondent in the meeting, my lord, that the present employees, because they have been working there for 8 long years.
That will leave it to the Deputy Commissioner to decide.
My lord will mention that because they said that if there's a court order, then only they can take that.
Yes. Yes.
And so far as the wages is concerned, also, my lord, we have been paying them 500 per day. But as per the government notification, it will be around 400, my lord.
That will take a cut in wages then.
Lordship, since for the time being we are running it, Your Lordship.
Yes, what is this case?
Your Lordship, I'm filing an impediment. I'm representing the 4 clans, Your Lordship.
Yeah, very good. Now we will bind you down also.
Your Lordship, the only issue that led to the protest in the first place was because there was no general darbar since 2010, Your Lordship.
Right. The court has
And
noticed
we have been filing representation one after the other before District Council. We have approached the petitioner, secretary, and the Linga of the Raj, Your Lordship. They are not paying any heed to our application, Your Lordship. And what we want is a darbar. And with regard to Krangsuri also, we want to be a part of it, Your Lordship, because since the time it was open, we were ostracized, Your Lordship. The other clans, the other members, there is mismanagement of the properties and the assets of the Raj. We don't know, there is no transparency at all, Your Lordship.
See, MS Omri, one thing, see, this court had noticed that when this matter had come before, and even the other connected matters, there's a lot of discord and dissatisfaction.
Yes, Your Lordship.
Because Raj Guam find they have not held a darbar. And so the thing is that what this court proposes is, in the interim, that tourism, the movement of tourists is not affected since it's
Yes, Your
a
Lordship.
space of unique beauty. So anyway, so this SOP will be in place till the dispute is resolved by the District Council. Now you'll be allowed to place whatever grievances you have before the executive member in charge Eleka or whatever, or the executive committee, who will hear you, will hear Raj Guam, and hear the president of all the 4 clans. So at least one thing you see from the proceedings.
Yes.
Now there has been repeated attempts to ask each member, one of the 4 clans, to appoint a person to represent them, like a kini, so that, effective, order, whatever effective work can be carried out. But what has happened is that as per submissions, on one day, someone else will come, another squatter will come next day. So these things can't be allowed to happen. And if these squatters remain there, they'll be held for contempt. That is one thing you must be clear. They'll be summoned. We'll know what orders to pass.
My limited.
So I think that it's good that we will implead you. You are
representative of the four clans.
Very good.
Your Lordship, my limited prayer here is that last month also, Your Lordship, we had filed another representation. District Council will issue one direction to us, and then after a few months.
No, that is why this court is going to settle the matter.
Yes, Your Lordship.
Best possible solution will be arrived at. So that's why in the meanwhile, if the department look with this SOP that they framed,
yes, Your Lordship,
let them look after. You all there'll be a separate account maintained. So in the end, eventuality that the matter decided and it is seen that you have some right, then you will get whatever is due.
Your Lordship, then I make a prayer, Your Lordship, then even some members from the clan also reappointed, Your Lordship, to run the. Like to be appointed in.
That case, my lord, will lead to more complication.
Lordship, they may also be appointed because for 8 years, Your Lordship, petitioner has
the thing is that
mentioned.
The court is not going to pass on that. Court is going to allow the suggestion as given by the state respondents, since they would tide over the situation. Under the chairmanship of the deputy commissioner,
Lordship, yes,
the district tourist, whatever it is, let them manage it.
Your Lordship, then will they be allowed also to apply, Your Lordship?
It's not a question of making a reservation now. Suppose he doesn't know how to steer a boat.
Yes,
Your Lordship, we may be given a opportunity to apply, Your Lordship.
That suitability is subject. We cannot sit here and decide suitability of who to be appointed. Yes.
My lord, as far as district council, there are 4 clans, contested clans. Now they are self-styled representatives, but they should hold a proper darbar.
Yes,
Elected
my lord, in fact, I have.
And inform the district council, because district council cannot hear everyone.
Your Lordship, with regard to that, we have filed the authorization, Your Lordship, signed by the respective clan. Authorization has been filed before district council, but till date that application is.
You see, Mr. Shalla, the whole thing problem is shareholding business.
Yes, my lord.
So, shareholding.
That is the root cause, Your Lordship.
My lord, because
shareholding business is that now if you operate some business venture, then if they are stakeholders, then it should be given their due share.
That's why, my lord, let the matter be decided by the district council, because they are claim and counterclaim.
Exactly.
From our
spot now, which has prominence on the shareholding issue, everything
because
is given different color.
Because the problem here, my lord, all this while it's the Buam clan have been nominated the Lingdo, and they are running the right Buam. Now after Krangsuri comes to existence, my lord, and money started coming, then these 3 clans are coming and claiming, my lord. And my lord,
2010, Lord was not held.
And my lord, so far as the claim is concerned, they are claiming themselves to be the representative of the respective clans.
Have you copied in this case?
Yes, my lord.
You received?
Yes, my lord.
Have you got authorization there?
There's no authorization, my lord.
No authorization.
No authorization.
I have not. But this is as per the meeting.
It doesn't matter.
This is as per the meeting that
If
was.
someone else comes to self-style, then we'll deal with them. Yes. Yes, sir.
My lord, so far as this issue also that be open, we'll agitate it before the district council, my lord. In fact, my lord, we wanted the entire representative of the clans, the actual representative to come, That's why, my lord, we have proposed this one. So that the actual representative come, because now the problem is that they are saying that they're representative of the clan.
You have given this list. It's a Surong clan is represented by.
My lord, because I'm following this as per the resolution that was taken in the meeting held on 12/7/2004 of the Office of Right Bound. We are saying that the Surong clan, Mr. Ross Surong and Mr. Neil Surong should be the person who organize a meeting and appoint the Kini. Then Cream clan, Murtiman Cream and Albert Cream. Albert Cream is one of the persons who have come here.
I have an objection with regard to
Sumer clan, my lord, Happy Sumer, she's also here. And my lord, so far as Buam clan, we have said that the Lingdo will hold a meeting to elect the representative. Because the problem now, my lord, if the actual Kinis are not involved, then we'll be flooded with application, my lord. One person will come and say, no, I'm representative. Another person will come and say, I'm the representative.
Your Lordship.
So that's the actual problem, my lord.
Your Lordship,
Now, the application they are filing here for implement, there's no representative. So far as Buam clan is concerned, I'm seeing with full responsibility, my lord, that this person is not even the representative of Buam clan.
Your Lordship, with regard to the Buam clan, Your Lordship, I have objection because within the Buam clan themselves, there are conflicts, Your Lordship.
That's why, my lord,
And the application that I'm filing here, it's with
Plan
regard.
is not here in this case.
No, my lord,
Is there, Your Lordship?
they are claiming that Buam clan
I'm not
is.
claiming, Your Lordship, this is as per the meeting attended with
It's
the
one at a time.
SDO, Your Lordship.
Tumpang Buam.
From Buam, yes, Your Lordship, and even
But
letters.
you should notice to him also
Yes.
the case.
No, my lord,
SDO also, he was
some
present
other
in
person
meetings.
also came in the meeting, my lord.
See,
There-
we're not-
That's why, my lord, I said this issue, let it be decided by the district council, whether they have locus or not, my lord. But to involve the actual representative of the clan, we are proposing this, my lord, that order be passed, that the whole meeting and everything, nominate person, then the district council can look into the grievances. Because if self-style appointed people come and start claiming they are representative of clan, it will lead to more problem. No? Actually, this is
That's right, that's right.
because this is the actual problem when we are trying to resolve.
Okay, fine, listen. Okay, you say with Kriyam clan, Kriyam clan, adult Kriyam is there, so that's fine,
Yes, Your Lordship.
right?
Yes, my lord.
Then Sumer clan, Happy Sumer is there, that's fine.
Yes, my lord.
So the only issues with
Buam clan.
And Surong clan, right?
Yes, my lord.
Yes, sir.
So we'll implead number 2, number 4, and we'll ask them to resolve with regard to not Buam clan. He's representing Buam clan.
I'm representing two of them, Your Lordship. Because within the clan itself, there are conflicts, Your Lordship.
No, let
These
them-
are not self-styled. In fact, the secretary, who is the petitioner number 2, he is the self-styled secretary, Your Lordship.
This
He has
issue
not been
can,
appointed
this issue
by the
can be
Darbar, Your
decided by
Lordship.
the district council, my lord, because we
He
cannot
has not
agitate
been
that before
appointed by
here.
the Darbar. He
But
is
so
the
far it's
self-styled
concerned,
secretary, Your Lordship.
my lord, that
Okay, one
issue,
thing at a time.
yes,
Right.
my lord, that issue can be resolved before the district council. But so far as at
Even
present
this
is concerned,
issue, Your
someone has
Lordship, will be
to
resolved.
hold a
Even-
meeting, my lord, of the clan to
Yes.
nominate their
You do one
representative.
thing.
Yes,
Okay.
my-
Once you file a small written objection to the miss case, right?
yes, my
You
lord.
file it by Monday.
Yes, my lord.
Your Lordship, I may be allowed also to file my authorization because I have duly authorized these people who are
Yes,
filed in the.
this case 163, prices first, 2024, WPC number 286 of 2024. This is an application for impleading the applicant's name therein in the connected writ petition on the ground that the said applicants are representatives of the 4 clans, namely Urong, Sumer, Buam, and Kriyam. Stop. Next, para Mr. J. Shalla, counsel for the petitioner, has, however, raised objections to applicant number 1 and 3 on the ground that these 2 applicants do not represent the clans given therein, nor have any authorization been filed before this court showing the same. This is the matter that an objection be filed within 2 days to the completion of respondent number, applicant number 1 and 3. As far as number 2 and 4 is concerned, property shall be arrayed as respondent number
9 and 10, Your Lordship.
9 and 10 in the main writ petition. Which to make necessary corrections. Yes. Then, in the main case, apa buat sambil sikit buat suami. Pursuant to the order dated 29/8/2024, whereby the question of modalities for operating and for managing operating the Karangsuri tourist site were deliberated. the respondents today have on affidavit. I replaced the minutes of the meeting held on 2/9/2024, chaired by the Deputy Commissioner West Karachi District, which was convened to discuss on the plan to run the tourist facilities at Krangsuri, Amlarem by the District Tourism Promotion Society, bracket DPTS. An SOP has also been generated to be put in place in the interim till the disputes between the clans claiming when clans are settled. Next paragraph. This court has examined the SOP, which has been annexed at Annexure
2, Your Lordship.
Annexure
The
2.
SOP is at page 10.
Annexure 2, the affidavit, and the same for the sake of convenience is reproduced here and below. So, the preliminary SOP or the conditions mentioned as no objection has been raised by the petitioner to the conditions given in SOP, but only a prayer has been made that as there are existing workers and personnel who have been engaged in the tourist site, they be given due consideration when the staff are selected by the District Tourism
Promotion Society.
Next paragraph. In view of this development, it is the SOP as presented is adopted, and the same shall be in operation until the disputes have been. Yes.
The SOP shall operate immediately, Your Lordship. Will take
Okay,
over,
we'll
will run, Your Lordship.
Okay, we'll add that. Still the matters adjudicated by the
Lordship.
By the GHADC, by the Executive Committee of the GHDC, who shall hear and decide on the claims and counterclaims made by the petitioner and the four clans. Stop. As the matter regarding Surong and Buam clan, representative still is to be determined. Final orders will issue on the satisfaction of this court as to the authenticity of the claims to be representatives of said clans. It is further provided that the SOP shall be given effect to immediately, so that the tourist traffic and those have been not affected. Also affected, and the people in the surroundings not affected. It is further provided that the district administration shall take necessary steps, further issue notice if necessary to the by informing the squatters or protesters to vacate the site, failure of which shall be taken up as suo motu contempt by this court.
My Lord, my humble prayer that it be reflected in the order also that the District Tourism Promotion Society should give a wide publication that the Krangsuri tourism spot is open.
Needless to add, the order of this court and the SOP that to be adopted shall be given wide publicity by the District Tourism Promotion Society.
That Krangsuri has opened, my Lord, because as of now people are thinking
They will do it. Yes.
Yes, ma'am.
Yes. Yes. List this matter after
on Wednesday, my Lord.
Wednesday.
Yes, my Lord.
Yes. So we listed on Wednesday's what date?
11.
12. Listed on 12th September. So this is a matter of you bring your authentication.
Yes, Your Lord.
Then if they accept it, then we'll bind all of you. And if you do anything wrong, then other very adverse orders will follow.
Because the only grievance that they have is with regard to the.
I think we need SOP
bar, Your
all
Lordship.
tourist sites to stop all these, what do you call it? Elements
If
from
the sharing system is worked out among them, I believe
Because-
that after the wisdom of Dr. Mosika's clients.
All my Lord.
18.
Blasphemy.
Yes.
Please, Lordship. You have taken the step to issue notice to private respondent. On 22.
Yes, affidavit.
Yes, Lordship. 2 weeks' time, Your Lordship.
MS and Raji please himself on behalf of the policy. Please follow out for the 2 weeks time for affidavit. This after 2 weeks for after for service report on spot number 4.
Mas Lordship.
Hearing supplementary list. Item number 3.
Yes. How long will it take? 10 minutes.
Your Lordship, I have already finished my argument, if Your Lordship would recall. That's my concluded my argument, and only limited issue as to the maintainability of writ petition is maintainable or not. Only 5 minutes. Because I have so, my Lord, to recall the facts briefly, my Lord. What is under challenge, Your Lordship will see the order of the state dated 22/12/2023 at page 176, my Lord. Kindly see page 176. Prayer, and Your Lordship will see the prayer and page 176. 2 pages only, my Lord. Prayer, Your Lordship will find at page 20.
Prayer?
Page 20, 20, my Lord.
20. Yes.
That the Honorable Court be pleased to issue writ of certiorari, any other writ or direction in the nature of certiorari, calling upon papers and proceeding which culminated into the issuance of impugned termination order bearing number 22/12/2023, and after examining legality, validity, and propriety thereof, be pleased to quash and set aside. And pleased to issue writ of mandamus to withdraw the impugned termination order dated 22/12/2023, my Lord. And this is the all relief is relating to 22/12/2023, my Lord. Kindly see the order dated 22/12/2023 at page 176.
22/12/2023. Page
176, my Lord. Paragraph 1, my Lord, kindly mark also subject, but Your Lordship will see the contents, my Lord, of the notice.
Yes.
Whereas the caption preliminary agreement was executed between you and the government of Meghalaya for survey and investigation of Upper Cree Stage 1, 15 megawatt, and Stage 2 megawatt in Meghalaya and build, operate, transfer basis. Whereas the total amount of upfront fee required to be paid is 1,25 lakh, but you have paid only 118 lakh.75 lakh, showing a failure to pay full amount after a gap of more than 10 years. This upfront fee stands forfeited as per clause 4 and 8. 3. Whereas you have failed to reimburse the government appropriate state power utility 50% of the amount spent by the government on an investigation and infrastructure work of the project totaling 145.18 lakh, and that is 72.5 lakh as per clause 16 of the preliminary agreement. Whereas the clause 9 of the preliminary agreement required certain milestones to be achieved by you, and you have failed to achieve the same despite numerous opportunities given to you. 5. Whereas the appraisal report of the detailed project report of 13 December 2015 of the above two projects weighted by MEPGCL showed that projects are not financially viable with tariff cost of rupees 9.3 kilowatt for Upper Cree Stage 1 and rupees 8.18 for Upper Cree Stage hydroelectric power project. 6. Whereas the terms of clause 12 of the preliminary agreement, it is clearly stated that preliminary agreement shall be valid for a period of 1 month and after due date of submission of DPR or signing of implementation agreement, whichever is earlier. In terms of clause 12 of the preliminary agreement has come to an end within 1 month of submission of DPR, that is 12/1/2016. Therefore, preliminary agreement is not in existence as of today. 7. Whereas the clause 13 of the preliminary agreement, the liberty was given to both sides to enter into implementation agreement only when both parties are satisfied with techno-economic feasibility of the project. Whereas Government of Meghalaya is not satisfied with the techno-economic feasibility of the agreement, therefore it is at liberty to not to enter into implementation agreement. 9. Whereas you have placed the proposal in midst of review meeting held on 19 February 2022 seeking certain concessions, namely A. Waiver of additional 10% free power to the government offered by you during the bidding process over and above 12% free power to the government as per state power policy. B. To include the development of approved road and infrastructure facilities other in the state budget to relieve the developer from financial burden. C. Waiver of charges for hydro and meteorological data to be paid by the developer for receipt of the said data from MEPGCL for formulating DPR. D. To take into account additional power that will be generated by downstream river on account of diversion of Upper Cree River from two projects. E. To avail soft loan from MIDC against projects since banks are reluctant to extend financial support for. Whereas the said terms and conditions are not acceptable to government and also amount to post-tender modification and are not in public interest. 11. Where you have also shown complete apathy in pursuing the matter in right earnest, which has led to inordinate delay in implementation of project, and you have also failed to attend the review meeting for all projects held on 20th April 2022. 12. Whereas you have failed to raise an artificial, fictitious, bogus claim of 15.4 crore, whereas state has suffered loss on account of your act and omission. You have to no basis of above claim. Whereas the state is entitled to compensated for losses caused by you inordinately delaying the projects and submitting effective DPR and not making the payment in terms of the preliminary agreement. Now, therefore, in view of the above and exercise of power under various clauses 29 of the preliminary, it is reiterated that preliminary agreement is no longer in existence. The said aspect is hereby informed to you by way of abundant caution. 14. Next page, that is further submit informed that upfront fee paid by you is stated and forfeited as per clause 4 and 8 of the preliminary agreement. This is further inform you that you are not entitled to any further claim of preliminary agreement arising out of in relation to lapsed preliminary agreement of 9/5/2014. The instant order is being issued in accordance with preliminary agreement and is without prejudice to entitlement of government in accordance with law. So what this notice, my lord, has been treated as termination. It is basically clarifying the various aspects of the matter, my lord. And what my friend is seeking in the writ is that this order has to be set aside. Prayer is that they set aside the order. For setting aside the order, my lord, what is required, what they are trying to, in a way, enforce the preliminary agreement which has already come to an end, my lord, because the clauses are very clear, my lord. And your lordship has seen that there are so many disputed questions of fact which would be required to be evidence are required to be led by parties in this regard, my lord, whether the state is at fault or contractor is at fault. This aspect has to be seen by in the detailed proceeding. In my humble submission, writ is not the adequate and appropriate remedy, my lord, for this kind of exercise, my lord. And my friend has not shown what is the arbitrariness or illegality in passing the order in terms of the contract, my lord. Moreover, if the prayer of the petitioner is allowed, my lord, the effect would be giving effect to the agreement which is determinable in nature. And a specific relief act, my lord, clearly bars this kind of enforcement, my lord. May I take your lordship to the specific relief act?
One thing, Mr. RP General, Now, you see, you say that this letter is not letter of termination, correct?
Yes, my lord.
It's not letter of termination. But then
This is
the subject
clarified.
itself says termination of preliminary agreement.
Yes, my lord,
Termination of
it is
preliminary agreement,
clarifying.
letter dated so-and-so executed between the Government of Meghalaya and so-and-so. Then how do you say it's
Yes,
not
my lord.
then
No, your
both
lordship is
under
right.
both the captions in the subject
Yes, my
one
lord.
and you speak about termination?
Yes, my lord, your lordship is right that the use of word in subject title of the letter is not appropriate. But that will not decide, your lordship is aware of the legal position that title of the document is not the basis on which the contents of document have to be read, my lord. If I can place one short judgment on this issue, my lord.
No, one second. Another thing is that they say that the writ's maintainable because why this order, why this letter is arbitrary, is that they were never heard. If we are deciding the case of the petitioner, at least some opportunity given to them, because they also submitted that time was never the essence in the implementation of the contract.
Yes, my lord. Now, if I answer, my lord, I answered both the queries, my lord. First query is, my lord, with regard to the use of word termination in subject matter, my lord. Kindly see the judgment of the, because it is the contents clearly show that there is a claim by the petitioner of 15 crore rupees. There is a claim by state government against the petitioner, my lord. There is a assertion by the state government that the state government is not willing to enter into implementation agreement. So therefore, my lord, if this order is set aside, assuming, my lord, the effect is that I have a claim against them, they have a claim against me, lord. And what they are saying is that, and the state has taken a policy decision after examining that it does not want to enter into implementation agreement, my lord. Whether there can be a direction to force the government to enter into the implementation agreement, my lord. But before I go to that issue, my lord, on the issue of title, my lord, kindly see this 2008 4 SCC page 451. 2008 4 SCC page 451, my lord, paragraph 18 and 19. Only two paragraphs.
2008
4 SCC page 451.
My lord, we have a copy. We have a copy.
Teacher's Day.
2008 4 SCC page 451, paragraph 18, my lord. Paragraph 18, where the principles have been discussed by the Honorable Supreme Court. Paragraph 18. The document in question, which is filed as Annexure P3, has been styled or titled as Certificate of Grant. In order to know the real nature of the document, one has to look into the recitals of the documents and not the title of the document. Intention is to be gathered from the recital in the deed, the conduct of the parties and evidence on record. It is settled law that the question of construction of a document is to be decided by finding out the intention of the executant, firstly from comprehensive reading of the terms of the document itself, and then by looking into to the extent permissible, the prevailing circumstances which persuaded the author of the document to execute it. With a view to ascertain the nature of the transaction, the document has to be read as a whole. A sentence or term which a term may be used be determinative of real nature of transaction. Reference in this regard can also be made to the following cases: Vidyadhar versus Manik Rao and the other judgments, my lord. Paragraph 19. The above principles make it clear that we have to see the terms and conditions and recitals in the document and not the title alone. Though the document, according to appellant, certificate of grant, perusal of the clauses therein clearly shows that land was sold on 4th March 1948 in a public auction and Motapa purchased the same on so-and-so. In addition to recital, so-and-so. So ultimately, my lord, the principle is that title of the document will not decide, its recital contents will decide. And in humble submission, my lord, contents clearly show that the various clauses of the preliminary agreement have been discussed. Various breaches of the agreement have been discussed. The intention of the government and negotiations which have also been discussed, my lord. That is why negotiations also, certain proposals have come from the petitioner, certain replies have come from the state, my lord. To that extent, hearing is also there before any conclusion is reached, my lord, because I have referred to the minutes of the meeting in the impugn order, my lord, at page 177, where certain 177 in clause 9, my lord, certain proposals have been given. Clause 9. It's not that, my lord, it is a process through which this result has been achieved by the state government. Page 9, my lord. Now, when there is a no preliminary agreement, my lord, I put a question to myself, my lord, in commercial contract, if the lordship will hold that the hearing is required, my lord, then possibly in all commercial contract, a state will be required to give them hearing, my lord. In commercial contract, your lordship has maintained that those contracts are to be implemented and executed in terms of those clauses, my lord. And the contract did not envisage any hearing by the state to the petitioner before it takes a decision in terms of the contract. I have taken a decision in terms of the contract, my lord, paragraph 9 of page 177, where your lordship will see the counter proposal is given by the petitioner for effecting or implementing the implementation.
One thing when you
see,
see now this contract of agreement was of some vintage, right? But I think the very fact entered into the discourse again, like with regard to constrained termination, if by efflux of time, forget about it. It's over. They give the Form 15, nothing happened after that, they never give termination. But then the very fact that you took up the matter for consideration again, that means that the cause of action still survived. In a sense that then you went into the exercise of terminating them, okay, notwithstanding the title caption of the subject matter, but to the entire process of.
I bow down, my lord.
Yes, and the thing is that now if you go into a process of adjudicating any matter, like on its merits, that means it stands to reason that the person against whom the orders are being passed deserves to be heard. Simply put, that's all.
My submission,
As a justice have been violated, then means he has to be heard. Might be you have 99.9% case in your favor for termination.
No, right? My submission is my submission is that in such contracts, the party is not required to be heard before decision is taken.
Commercial, you mean in commercial?
Commercial contract
might not be signed on, but
commercial, and without prejudice to my first submission, my lord, parties have negotiated with various terms and conditions, and parties have failed to arrive on those terms and conditions. So therefore, my lord, it's not that there was no attempt to discuss and negotiate, my lord. Third, my lord, notice has been issued by the claimant seeking payment of 15 crore rupees. I have said you are not entitled to this payment, and I have said I am entitled to forfeit the amount, my lord. Now the contract also envisages that the parties have the dispute, they will invoke the arbitration clause, my lord. This is a commercial contract, my lord. In commercial contract, I am saying I am entitled to X amount. The petitioner is saying it is entitled to Y amount. Therefore, my lord, in commercial contract also, writ is not maintainable. All the and hearing is also not required, my lord. And moreover, we have tried to negotiate, and this is a lapsed contract which cannot be revived, my lord. That is my humble submission, my lord. And on this, my lord, 3 judgments I am placing on this aspect only briefly, my lord. 3 judgments, my lord.
Good judgments. MS Pony, where are judgments?
Yes. The compilation, my lord, I have given on last date of hearing. My lordship, kindly note only the compilation.
Okay. Your
lordship, yes, my lordship will see first a specific relief act, my lord. Kindly see the specific relief act, section 10, my lord, and then the judgments on that.
Well, yes, sorry, I couldn't catch you.
Kindly see the specific relief act, my lord.
Okay.
My lord, we have a photocopy, lordship. We have a photocopy.
Yes.
Kindly see section 10, my lord.
Yes. Specific performance, respect contracts, yes.
Yes, my lord. The specific performance in respect of contract. The specific performance of a contract shall be enforced by court subject to the provisions contained in subsection 2 of section 11, section 14 and 16, my lord. Subject to, so the performance is subject to 3 conditions, my lord, and your lordship will see 11.2.
Yes.
Contract by a trustee, my lord. We are not concerned with this aspect, my lord. Kindly see 14, my lord.
Yes.
Contract not specifically enforceable. The following contract cannot be specifically enforced, namely, where a party to the contract have obtained substituted performance of contract in accordance with provisions of section 20. B, my lord, a contract the performance of which involves the performance of continuous duty which the court cannot supervise, my lord. I am covered by B also. C, a contract which is so dependent on the personal qualification, we are not concerned with personal qualification, my lord. D, and contract which is in its nature determinable. So B and C clearly shows that the contract is not enforceable, my lord, and personal bar to relief, if your lordship will see section 16B also, because there are 3 sections which have been referred. Section 11, 2, 14 and 16, my lord, in section 10. Section B, who has become incapable of performance and violates any essential terms of contract on his part remains to be performed, my lord. So I have also raised that issue of 16B at section 11, section 14. B.
Okay, you show a judgment which, the only the point troubling the court on whether like natural justice is a sign point on in termination.
Yes, my lord, because
yes. Which
so far as natural justice is concerned, my lord, the law is well settled. Our first judgment is Pimpri Chinchwad, my lord, at page 98, page your lordship will see page 102, my lord, of the compilation.
It's the middle of the judgment.
102. This is a part of the judgment that starts from page 98, my lord, and the relevant paragraph is at 102. This is 2008 8 SEC page 172.
Yes.
And the relevant paragraph is paragraph 11, my lord. In matters relating to maintainability of writ petition in contractual matters, there are catenary of decisions dealing with this issue. In National Highway Authority of India versus Ganga Enterprises, it was entirely held as follows. Respondent then filed a writ petition in the High Court for refund of amount. On pleading before it, High Court raised 2 questions: whether forfeiture of security deposited without authority of law or without any binding contract.
Okay, we don't just where's the finding?
And your lordship is finding there all series of judgments have been culled out, paragraph 12, 13, my lord, and the final finding your lordship will find 17. Therefore, the High Court ought not to have entertained the writ petition, my lord. Then, my lord, Delhi High Court judgment also is there up to 2012. But that is not relevant, my lord. After the Supreme Court judgment is good enough, my lord. Then your lordship will see one more judgment, my lord. Noble Resources at page 33, and the relevant paragraph is 43, my lord. And paragraph 43, my lord. Page 47. Ordinarily, a specific performance of contract would not be enforced by issuing writ or in the nature of mandamus, particularly when keeping in view of the provisions of a Specific Relief Act 1963, damages may be an adequate remedy for breach, my lord.
Yes.
Now, your lordship, after showing this, your lordship may kindly see my counter affidavit, where I have culled out all the relevant paragraphs of the judgment on the maintainability and hearing also, my lord.
You will see that, yes. That's it.
That's the counter affidavit, my lord. Kindly see those judgments, my lord.
We'll continue after lunch.
My lord, only I am some difficulty because in NGT principal bench, one hearing is kept at 2:30 in NGT in here, principal bench.
So you're going physically or you're appearing virtually?
Physically, my lord, because Punjab has been saddled with liability of 1,000 crore rupees for solid waste management and liquid waste management, etc. So the government.
So how
and
much
all
longer will
officers
you take to complete submissions?
My submission is complete, my lord. I will. My only thing is that I have shown, my lord, two part, and my judgments, your lordship, may kindly see in those counter affidavit. Only 2 minutes, my lord. Only page 7 of my counter affidavit. That's all.
Okay.
And I have culled out the relevant paragraph, my lord. Only note down the page at page 7, my lord.
Affidavit filed in 316 this?
Yes, my lord.
The two
This is the
petitions,
affidavit
correct?
filed in 18 of 2024, my lord. 18 of 2024.
My lord, it was filed on 20th June 2024. Yes, my lord, 2026.
No, in petition 18, 1-8.
Yeah, the date is 26.
No, in which petition?
18, 1-8.
24.
Yes.
My lord. And the affidavit was filed on 26.
It comes here. Yes. Okay. Right. Page 7, what do you say?
Page 7, my lord, I place the authorities and the relevant paragraphs, my lord, on.
Page 7. Okay.
Page 7 onwards, my lord. It is there, my lord. The principal and the, my lord, I have not culled out here. In the other connected, in the counter affidavit, my lord, your lordship will see that also. Along with this, only your lordship note down the pages number. At 3, and your lordship, the 362 counter affidavit is also on record, my lord. That your lordship will find at page 157.
You prepare the bullet points, correct?
My lord.
Give them, I'll see, yes.
And I'll place the pages. And I have got a note also, my lord. I have prepared a small bullet point notes also. I'm submitting that also, my lord.
Yes.
No, it will be kept on 10th for reply. So that's would reply. 10th.
Yes. Petitions concluded this argument. Stop this on 10 for reply by the petitioner. Rest of the matters at 2:15.
Grateful, my lord. Grateful.
Open.
Item 19.
Yes.
This is the contempt matter. These two matters, item 19 and 20. I appear in item number 20. Mr. Pathak is there in item number 19.
That amend the parties will.
Yeah, this will never end then.
The difficulty, even we have expressed before your lordships that this matter, both these two matters have actually travelled right up to the Honourable Supreme Court. And in subsequent proceedings before your lordships also, certain orders have fallen where your lordships have held that, that expression could not be used. It could not be treated as an upgradation. It was a case of redesignation.
But what contempt lies here? It's the whole complexion has changed. What started as a simple contempt now has become a lot.
What has happened here is, they say that they have allegedly complied with the directions passed by this Honourable Court. Now, the difficulty arises, because of the wording of that particular order, which have clarified in the subsequent judgment. Because that aspect fell for your lordship's kind consideration, and your lordships held that it was... Yes, that your lordships have now taken a view that it had to be a case of redesignation, could not be upgradation. So the moment it becomes redesignation, insofar as our cases are concerned, they all get covered.
Then why are we persisting the contempt then?
This litigation has been going on
at the time, because there is an allegation of non-compliance with the order of 2015, my lord.
2000.
Because there was no clarity, my lord. And that was clarified by lordship in 23, my lord. So can we be held for contempt for that? There is no element of willful disobedience of any order, my lord.
Before that petition, sir.
My lords, we have been before your lordships, my lords, right up to the Supreme Court for almost like 15, 16 years, my lords. And it's not one person or two persons. There are a few thousand people who are before your lordships in these two matters.
As far as this contempt, my lord,
if your lordships have now taken a view, that should not stop them from, my lords, taking a fresh decision on this entire matter, and the matter can be resolved.
But that should be by way of a
No, but you mean to say that these people here have not been given the benefit?
No, my lords. Because the moment it becomes, my lords, the moment it becomes upgradation, the entire complex of things changes. As a matter of fact, my lords, in my learned friend's matter, there is a compilation which has been filed. At some point of time, we had filed it. My lords, your lordships will see that their effective date of joining becomes one for a few thousand people. So everything just goes topsy-turvy only because of that one word, my lords, upgradation.
My lord, they've been given all of them, my lord, the rank of Havaldar as per the directions of the Supreme Court, my lord. Now the fixation of pay, my lord, there is a certain, they're agreed with fixation of pay. That is what is left, my lord.
Not only the fixation, my lord, what was the purport of this entire thing that flowed from the Fifth Pay Commission, my lord, was that for the technical trades, my lord, there were three categories, class 3, class 2 and class 1. So these are tests that you have to pass. And the Fifth Pay Commission said that you restructure the organization on the basis of the class they have completed. So the class 3 people become Havaldar, class 2 people become warrant officers, and then the class 1 people become Subedars. So accordingly, the cadre was to be restructured. Then that was the direction passed in all these cases. So, so people who have done class 2 have been also made Havaldar, my lord. That is the difficulty.
The court understands that. But what is before us is contempt jurisdiction.
My lord, I understand that.
Where we can't pass directions.
No, my
lord, to see whether there's, there's been compliance or not.
My lords, which I again bow down before your lordships, my lords, the only thing I would pray for your lordships' kind consideration, compliance has to be, my lords, in spirit of the purport of the order. If I deliberately choose to, my lords, subvert the directions and show an alleged compliance, my lords, that would tantamount to contempt. Subversion is contempt. And, my lords, that gets fortified by the fact that subsequently, my lords, when these orders were challenged in writ proceedings before your lordships, my lords have taken a view. So the law, insofar as, my lords, the compliance is concerned, your lordships have found that it was not compliance in the first place.
My lord, any contempt matter pending for 9 years plus, my lord, that in itself shows that there is no contempt matter.
No. See, because these
No,
are
that
matters
itself,
which-
I think, probably shows that there is something to look into. The other way around.
It's not that. It's just like, because this issue was a living issue. It did not end there in 2015 with this, what Madhuvendra Singh. It went on. There's another subsequent litigation, went on, it went on and went on. Other trades, other cadres. So that is why, it's just like a river.
Now, that's what I'm submitting, my lord. Lordship has decided.
Decided your only ground is whether there was now can we turn back the clock and say that whether you complied the order passed in that WP was this
My lords, these two writ petitions.
Yes.
But because your lordships in the subsequent matter, your lordships have found that compliance was not an actual compliance.
But can we draw sustenance from that later order?
My lords, in my humble submission, yes. Because your lordships, if I say, my lords, before your lordships that there is compliance and it gets independently examined in a, my lords, analogous proceeding, where your lordships, my lords, come to a finding that no, there was no compliance, that would have a bearing on this, my lords.
And precisely, my lord, these were also the grounds taken in the FLP.
Bearing. It can clarify, but can have a bearing because then you cannot hold them contempt orders, which they see that they're not clarified. Now, as per the submission, say that.
My lord, what we have been submitting as of now is that contempt, we understand the punishment aspect apart. There have been some recent judgments of the apex court where it has been clarified that to ensure proper compliance, further instructions in terms of the original judgment, not additional directions, can also be asked to be made, my lord. Even recently in 2024, my lord, this issue has been reiterated.
When we can, maybe you can file a
We'll file a petition. Practical difficulty of it is, my lords, the Union of India will ensure, my lords, that the matter goes right up to Supreme Court. Then we'll come back, then there will be part compliance, and again we'll be in the same situation, my lords, where we are before a court for 16 years without getting a penny.
Humanities people have not got any substantial relief.
My lords, substantial relief, no. As a matter of fact, some people, my lords, there are situations, my lords, where people, when they are retiring, there is recovery to be made from them.
So that has been settled. That has been corrected. The recovery has been corrected, and even I think the pay scales has been that's all been that has been done. I remember
has been done. In respect of individual petitioners who came before your lordships.
Yes, in earlier
lordships.
I remember that. Yeah.
So this is the compliance, my lords. The compliance has essentially led to a situation where, my lords, there would be recovery from people.
And I had also pointed out, my lord, the similar issue as far as overall is concerned. In Kerala High Court, the DG's personal appearance was given. They filed a petition, my lord, for exemption, which was rejected. Against that, my lord, as per the last order, it seems that the union has preferred to move to the Supreme Court again, my lord, on the same issue of compliance of the same judgment as to the rank and pay. This is the last order, my lord, of the Kerala High Court, where the submission was made, my lord, that some breathing space for going to the Supreme Court, my lord, again has come, my lord.
It'll never stop.
We are against, my lords, the might of the Union of India.
No, but you achieved a lot because the might in India, they made the initial mistake, and so that is why they're paying the price, which is very heavy.
I will not call that a mistake, my lord, because the number of court orders have come, my lord, which has reaffirmed that.
Various high courts have taken the same view.
All rely on this honorable court.
It's from Kerala High Court.
My lord. Seeing compliance of surrender thing, class wise or rank wise, my lord. The cadres, my lord.
Breeding time.
Dr. Mojiga would know better if SLP has been filed or not.
They have substituted this General Pradeep Chandra Nair, now he's also retired. In this case, both of them.
Yes.
Now,
it was to come up on second. It has not come up because.
Now, second, different.
This is the second difficulty, Malus. Which is why, Malus, also the officers tend to take it very casually because they know, Malus, they're here for a limited time. Once they demit office, Malus, there are no consequences.
No one wants to take the fall. They will not. Everyone working in a such as India established, they don't take a call. Why should they? So what should we do? Dispose it off?
Well, it's there are only 8 contempt petitioners here. They can easily file a writ petition.
Only 8 of them.
Only 8
No,
of
no,
them.
no. See, it's not a question of their ability to file. It's the apprehension. That once they file a fresh writ petition for implementation of orders, then you will come out with guns blazing. Your the petition be allowed from here. You'll go back.
Well, it may be the other way around also.
Again to SLP.
But
and hope for some,
It can be the other way.
What had happened is
Lordship has already decided.
Cast an order. Division bench Malod's appeal was not pressed. Judgment became final. That order was taken to the Supreme Court. Again, all the grounds Malod's urged were again re-urged before the Supreme Court. Supreme Court dismisses it. Malod's making some scathing remarks. Matter comes back here. They say alleged compliance, and we are before your lodges with the so-called alleged compliance.
Yes.
My Lord, Lordship has decided that exact issue in 2023, my Lord. Can anybody be held liable in 2015 for disobedience of that, my Lord?
No, that, my lords, I think my learned friend has put it
I think the case was decided last year by Lordship.
January, I think.
This January.
Last January.
Last January, it's 23.
I remember, yes, that's not a case of resignation. Yes.
So what if I may put it, my lords, it cannot be a case of putting the cart before the horse, as my learned friend is trying to put it. There is an alleged compliance, my lords. Your lordships have found that the compliance has not been a compliance. Matter ends there.
So the judgment.
Supplied a copy, Asim Debroy, and there was another matter decided by the Guwahati High Court. Both pertains to the cipher trade, which my learned friend is arguing. And then for the ORL, my lord, the same has not yet been extended. What had happened in our compliance?
So cipher, there's no quarrel now. Cipher.
Cipher has been finally settled, my lords.
Yes.
Cipher and ORL. For ORL, my lord, initially the compliance order they had filed, they said that it is, you are redesignated. Then that order got corrected by another order saying that it is redesignation oblique promotion.
Yes, I remember. Yes.
My lord, when the division bench, my lord, the appeal was pending at that point of time of the same judgment, and in the meantime, against the interim order, SLP was filed. After the SLP was dismissed, my lord, the division bench left the issue to be then adjudicated in the contempt. That is how the ORL contempt survived, my lord.
Lords, I'm sorry, my lords, that judgment is not here with us. May I pray your lordships to just have this matter at the bottom of the list? In the meantime, we'll just obtain a copy of the judgment. It had been, my lords, filed at some, it was placed at some point of time, my lords, before your lordships.
You said it.
Yes,
अच्छा ये आपका है इसमें नहीं होगा इसमें फाइल नहीं है कोटेड है लेकिन फाइल नहीं है इसमें तो केरला वाला लगा हुआ है
That order has not been challenged.
You not gone to Supreme Court against that order or to appeal?
The Supreme Court order in our case is filed in the additional affidavit on.
File become too voluminous.
It has become voluminous. I had therefore filed a separate comprehensive compilation also.
I'll just say structure of it because become very messy. I didn't make out also. The Pathak, you come again, then why he will finish it off?
my lord. In fact, I would actually like to wait the outcome of what happens to the SLP now from Kerala, my lord. Some compliance they have to file now there.
Yeah.
Either way. So if the matter is taken seized up by the Supreme Court, of course it would
After
be
2 weeks,
different.
then we'll settle it. But please, because Mr. Paul is a very busy counsel, so when the matter comes up,
Well, let's not be him.
Usually,
But in the meantime, if they choose to, they have to amend the cause title also.
well, let's leave it at that for time being. Let's try to close it without opening the topic
Well,
again.
what I would pray is, even if it falls from your lordships in these proceedings, in an interim order, my lords, that they can relook into this entire matter in view of the view taken by your lordships in that.
I just let me accommodate Mr. Paul, because you see, the thing is stemmed from that division bench order 2011, where it's appropriate rank, pay structure be given to all. Now, where were deviations? Where were the the infractions? Where were the violations? So that we just have to see, and because
We'll try and flag it on the subsequent judgment.
So that's the only thing. Yes. I request all the counsels for the parties this matter to be
21.
I shall be made to dispose this.
19 ko.
After 2 weeks, eating any result comes SLP. Mr. Patak.
We'll find out, my lords, in the meantime.
Can we have it on 19th?
19th, well, it's subject to lordships.
19th.
Yes,
19th.
19th.
Obliged.
Deeply obliged.
Yes.
21.
Yes.
Shall I begin? If I start.
Here you start.
Not sure if you may recall this matter is with regards to it's an appeal against the order passed by the learned judge.
Yes.
In some substance, I am the legally wedded wife, the first wife. But after filing a succession certificate and a revocation therein, I was denied all benefits arising from the pensionary benefits of my deceased husband.
Yes.
So if I may take directly to the issues framed by the court, which is at page 61A.
Yes.
And there were 7 issues framed. The first issue is whether the revocation petition is maintainable. The second
Where's
is
the page?
61A.
The paper book or page?
61A.
61A.
Yes, sir.
Yes.
These are the 7 issues, Your Lordship. First issue is whether the revocation petition which I have filed is maintainable, whether the opposite party is the legally wedded wife of the deceased. Here also opposite party is the respondent. If so, how many children? Whether the opposite party never lived and cohabitated with the deceased after the marriage. The fourth is whether the deceased lived and cohabitated together with the petitioner, so-and-so since the year 1991. If so, with whom the deceased lived and cohabited together as husband and wife till death. Number 5 is who performed the last rites of the dead body of the deceased and who bore the expenditure of the same. Number 6 is who is legally entitled to inherit debts and securities left behind by the deceased. And number 7 is to what the relief other parties entitled to.
Okay.
My Lordship, I've been completely denied of all the benefits arising out of my deceased husband.
You are Misilda Lindo.
Misilda.
Yes.
Your Lordship, I'll just briefly make a submission that
Yes.
the reason for me being denied, despite holding that I am the legally wedded wife, that part of the judgment is in my favor. I am the legally wedded wife. But I've been denied complete benefits only on the ground that I had not stayed with the deceased person at the time of his death.
Okay. How long we separated?
Your Lordship, our contention is that we never separated. Because I was staying in Mairang, my husband had to work in Shillong, so he stayed in Shillong, and apparently he found a...
On the issue whether opposite party never lived and cohabited with the deceased after the marriage.
Yes, Lordship. In this issue, they came to the finding that I never lived and cohabitated since the year 1991 onwards. But there is no such depositions or in the crossing examination by any of the witness to that effect.
What about issue number 4?
Here, the finding came to the finding that the
respondent
lived and cohabitated. Another interesting aspect with these two issues. Here, the two issues are that who lived and cohabitated. Now, the learned judge of the District Council Court went to the extent of to the finding that the person who lived, that is the respondent, took care of the deceased person till the time was death. When there is no such issues and when there is no evidence in that regard, yet additional finding was given that they had taken care, but there was no evidence led to that aspect. Now, before I begin, first I have to establish that I'm the legally wedded wife, although the same is my favor. So what they have objected before the trial court is that despite me producing a marriage certificate, they are saying that the marriage certificate was not produced in original, as such not exhibited, and as such my marriage was not proved. My submission to that is that that is not even required for me to even furnish the marriage certificate. Because at the time that I filed revocation, show cause was filed, where they admitted my marriage, but they say it's null and void because I never consummated the marriage.
Okay, then.
So in my submissions that I do not need to prove my marriage even further by a marriage certificate because it's already admitted in the part of the...
What certificate did you supply?
A marriage certificate issued by the... it's just a photocopy.
Of what?
Of the original certificate issued by the church.
Record the name. Record the year. It's okay. Okay.
So Your Lordship is well aware that if a certain fact is omitted, it is not required to be proved under the Evidence Act. Section 58 is already there. So to this aspect, my marriage is confirmed. It's further confirmed by the finding of this, the learned trial court below, the learned judge. As such, my status of wife is upheld.
Yes.
Now I'll just stick to the judgment.
That's what the judge will judge of the judge has said.
I'll take the judgment.
Page?
Page starts at page 199. The findings start at page 212.
Yes.
I'll skip issue number 2 since this is already in my favor. Issue number 2 ends at page.
Would you read that issue number 2 again?
I'll read directly the finding at page 225 of issue number 2.
This is analysis of evidence.
Yes, Your Lordship. So
Okay,
lengthy.
225.
Page
Yes.
225 at the second paragraph. From the evidence on record, it is found that opposite party produced as paper mark 2 a proof of marriage with the deceased, and this claim of opposite party has also been corroborated by all other DWs. Therefore, after careful consideration of the matter, also in view of my above finding, I am satisfied to answer the first part of issue number 2 in the affirmative. However, as regards to the second part of issue number 2, the opposite party, when she examined herself as DW1, has in a cross-examination admitted that she has not got no issue from the deceased. Therefore, the objector herself admitted that she got no issue. Hence, I am the opinion that no further proof is required in this issue. Therefore, in my observation, I find that the opposite party have no issue out of wedlock with the deceased, and second part of the issue is hereby answered accordingly.
Do you accept the fact you never lived with him of 91?
So up to
You
19...
never raised anything, even in your evidence also.
We did not raise anything.
Yeah.
But after 1991, our contention is that he went to work in Shillong and he used to visit despite us not staying together.
How many children did this deceased employee have with the
Respondent, they claim to have 5 or 4 children, but their own witnesses have stated that the eldest daughter is not the deceased husband's children.
Doesn't matter.
That can be point out. I'll point out the evidence to that effect. Now, interestingly, all the so-claimed children, if you see, the birth certificate were issued after the death of the deceased person, that is the husband of the appellant herein. And the contention why they were all after, because the previous birth certificate were all lost, so I had applied new certificates. My humble submission, whenever a birth certificate is lost, we must issue duplicates, not new. This factor also was not looked into by the learned judge.
In the nominee, he had entered the respondent's name.
No, Your Lordship, that is one aspect that was never clarified. Because while I filed this revocation petition, even the sister of the deceased filed a revocation petition stating that the nominee therein is the sister of the deceased person. But the sister of the deceased person never participated till the finality of this trial. She withdrew midway. So the service books and everything were never part of the record, so it's unclear till now as to who has been nominated in the service books.
He could not be settled out of court, this one, no mediation, right?
3 times we tried while he was in this court.
And they had offer also before 6 lakhs, but they are not willing to accept.
You know what I submit is...
You offered 6 lakhs?
Yes, ma'am.
You know what I submit? We are not denying them of what is rightly theirs. All we submit is, whatever the pension is, the monthly pension, since I am proven to be the legally wedded and the first wife, so by law, that has to go to me, and the rest let them keep. Whatever 12 lakhs. But the monthly pension has to come to me, and that's all we ask. We do not want the lump sum amount.
Where was he working?
He's working at BSNL, It's a central.
When did he die?
A civil hospital, Shillong.
January of 2012.
So fund pension is being now stuck, not paid
It's
anymore.
stuck. It's accruing now. I think for 10 years it's been there. Since 2012.
Not, and how much money do you draw in the terminal benefits?
Almost 12 lakhs.
With your succession certificate which you obtained earlier. That means you're not aware about the earlier marriage of this employee, or were you aware that he was married earlier?
No, nothing.
That's why you never made party in that
Yes,
that proceeding. You came to learn about later on.
And moreover, my lord,
because the BSNL office had contacted us. Apparently, I think there are names there in the records. That's why they contacted us to get a succession certificate.
And moreover, my lord, it was a strange marriage. There is no witness from the relative of the deceased.
It was stage managed?
It was very strange. There is no witness from the relative of the deceased.
With regard to?
With regard to the marriage certificate as he claimed for.
No, but you admit that, correct?
No, marriage is admitted, it's in the show cause, they admit to the marriage.
And the finding also is there that, you have not filed a cross appeal against the finding.
Exactly, no
saying
cross
that
appeal
is the finding that, I noted it just now, where is that?
And moreover, my lord, it was expected only mere paper mark, which is not admissible in law.
Only thing, see, the finding of this judge entirely revolved around the fact that after 91, you never cohabited, it was no relationship of husband-wife anymore, and so she looked after him till last days. That's the thing.
Since I never took care of the deceased person, that's why I'm not entitled to any benefits. That's the finding that has gone beyond to what the issue
In page 225, regarding marriage, for evidence and records from the opposite party objector for his paper mark to proof of marriage with the deceased, and this claim also has also been corroborated by all the DWs. Therefore, after careful consideration matter, also in view of my above finding, I am satisfied to answer this part, issue number 2, in the affirmative. That means that is accepted. That so once this court has come to finding, the lower appellate court, the trial court has come to a finding that affirmative. That means some rights are vested with the appellant by virtue of being the legally married wife in the first instance. That's the only thing.
My lord, I do have one citation in connection to that, my lord.
Where you disprove that after that there's a clear finding. You have not filed any cross appeal saying that this finding is wrong.
Cross appeal or an objection to this finding in my
appeal. You have not filed it.
There's nothing to show. So they're not aggrieved by that finding.
They're not aggrieved. No, they can't raise it now to say that they don't agree with finding.
My lord, the way of the exhibit by way of paper mark is not an as per provision of section 64, my lord, Evidence Act. I also have some citation in connection with that section, my lord.
No, we're not
You never
going-
objected to it in the.
I have raised, my lord.
Where's the objection you made? You see,
107, my lord. Page 107.
when in the course proceedings, you never raised the objection.
My lord, I have raised, my lord. Oh, 108, can we come to page 108? Mary, my lord, the first part. Objective to the
Objection
document,
to the-
my lord. There is an objection. I have raised, my lord.
They didn't file an appeal to the finding of the judge. How do you examine it now?
Because
and this objection also does not sustain, you just have page 29 also, Your Honor. Is there show cause? 29, the relevant page, para is at page 30, para 4. It's clearly stated the present petitioner never lived with the deceased husband any time after the marriage. It means it is admitted the marriage is there. Only the thing is, we never lived and never cohabitated.
Another thing is that, see, Mr. Kasi, why, if you have said that it is not as per 1664, that's the primary evidence, and then why you have not, then you have not questioned that part, you've kept silent now, then you're precluded from. The only thing that.
My lord, in carrying with that also, I have given my written argument during the trial court. I've already stated there that it should be many as
No,
per
trial court fine, but the finding has come very clearly that if he found there are two important issues I can see, 2 and 4, I think. There are two important issues in this matter. Now, in issue number 2 is gone against you. Issue number 4 is gone in your favor. So, but issue number 2 gone against you. That means you have not challenged it, that part of the order. So you haven't done that. That means you have accepted the finding of the judge. The court that yes, it is answered affirmative that he is a legally wedded wife. And in your evidence also you said that I don't have any restriction of marriage. It is customary. The only fact is that I cohabited with my deceased husband. They were the deceased employee from 1991 till his death in 2012. Correct?
No.
That the case rests there only. And from that, out of the said wedlock, you had 4 children, whereas they were childless.
No.
Correct? But the fact remains that goes against you is that she is the legally wedded wife, as per the finding, which is
But has not been proved, my lord, by way of
yes
provisional, but has not been proved by way of provisions.
No. You have where that appeal. Your appeal is no cross appeal to say that that finding is wrong, that the introduction of the document is not as per section 64. is not a matter of secondary evidence, it's primary, that should have been introduced in original, whatever, that you have not challenged it anywhere. You've left it at that. So that's the thing. So you can't take those points now.
Yes.
The only thing left is that now the second part only that remains is with regard to the finding, which is challenge, which you have to defend. That the fact of cohabiting will entitle you, your client rather, to all the terminal benefits. That's the only thing. The only finding that remains for consideration, whether right or wrong, is the issue number 4, and we have to apply also the, either the general law applicable in such cases. That is where it stands.
Regarding with that, I do have one citation, if I may be allowed to.
What citation?
From Supreme Court.
Regarding secondary primary evidence?
No, my lord. Regarding another issue, regarding with the legal, whether it works, something.
Let us see. Because only thing customarily also we have to accept your position. We can't just throw you out also. That's the finding of the judge.
Para 12, 13, and 14. If I may just read only.
See, it is not a question of acceptance totally to your exclusion. That this court will not allow that also.
We are not even pressing for that.
Yes. The thing is that what has happened for the judge is that although coming to finding that she's a legally wedded wife, has to the exclusion of the appellant, has given in your favor. That's all. So that's what they agree with. This judgment is just succession certificate. Legally wedded wife not automatically entitled succession certificate to the exclusion of second de facto wife. So you're a de facto wife by virtue of your cohabiting with your husband. Because this law is well settled now. Whatever it is, even if you're not entitled person, then the children are not even, they'll be entitled to the benefit. So you have your children, so that is the thing. It's a very simple case to decided by mediation actually. I don't know why you can't come to one thing, Mr. Basa, I shall not advise from here, but if they're giving one-time settlement, you take it. As it is, you didn't cohabit with your
may consider your lordship the appellant here is an aged person, does not have anyone.
See, another thing that goes against you, I've just seen the evidence is that you came one fine day, because maybe that goes your favor that maybe your name's entered in the service record of your husband. Correct. So you were aware that you didn't know that he had died. You don't know the where he is cremated or buried.
Exactly.
You don't know who performed the last rites. So now, if you look at it from common sense angle, where is your
Lordship, in my submission, if my husband goes and finds another wife and estrange me, am I supposed to suffer, your lordship?
Then you from 91 you kept quiet.
Your lordship,
you're very happy. 91, you're waiting for him to die.
Lordship,
2012.
That aspect, that's why I've not been informed about anything. Although he has to come to my place at the time when he died, your lordship, nobody contacted me. I'm living alone. I'm an aged woman. How would I come to know, your lordship? I do not have phone.
Exactly, because you never cohabited with him. That also supports his case.
Yes.
The only thing that he has not done is made a cross appeal with regard to marriage certificate. That
all said and done, your lordship. All we want is the monthly.
No question, all said and done. We're arguing on. It's totally on points of law. Although, see, the thing is that in first appeal, this court can appreciate evidence, but in the absence of any challenge, so that doesn't arise anymore. And with regard to cohabitation, they've proven the case, and you also, by your ignorance about death, cremation, burial, also have you have proved your own case
to that extent,
that you had lost contact totally.
Yes,
to that extent. What remains a very simple thing is that it's better you accept it, and otherwise,
my consideration is that you
just hold the first appellate court order to the exclusion and give you just a. See.
My submission is that since I'm the legally wedded wife, I'm entitled to the monthly.
My legally wedded wife, so they've been kind enough to offer you settlement. Otherwise, if we have to generate a judgment, then
all we want is the monthly pension, Your Lordship. I mean, aged woman.
why should he be entitled to monthly pension?
Your Lordship, there are citations which I would like to submit, Your Lordship, where the legally wedded wife, the first wife is only.
Every case is set its own circumstances.
Exactly.
And some of these cases are very simple. There's nothing really difficult about it. Otherwise, that you decide, otherwise, then we'll pass orders. Might be to your total exclusion also in the circumstances of the case. I'm not saying it will happen, but.
Well, I'll have to leave it to Your Lordship because Your Lordship is aware that we tried mediation 3 times. But never.
It won't work. I mean, you have to call the people here.
We tried our best.
How old is the appellant now?
Which is around 70. That's the age. In 2012, she was 60. Now she's 74 years.
And the respondent?
Respondent will be 53 with able-bodied children.
That stands to reason that she should take a family pension. Yes. You produce some parties on that notes and Kasi law, we just have a look regarding customary marriage. We'll reserve it.
The note is from their side.
Yes, where you want to file submissions?
No, Your Lordship.
Don't to file submissions.
No, I'll just place some citations. I'll just file a compilation of that judgment.
File it. You want to file any submission, you can file it.
I'll just file bullet points, Your Lordship. A few.
Yeah, you list it up to 1 bullet points and we'll generate the judgment. Yes, you understand the mind of the code. Yes.
Obliged, Lord.
22.
And also, Mr. Khatri, you can't raise those points, section 64 now, you are stopped. Yes. Yes, I'll wait for bullet points and.
This is the matter concerning the escrow account.
Yes,
Lordship
Mr. Datta, we've been waiting the whole day. It's your luck today that the court's gone on for long.
I was enjoying. The issues here were, very limited to the admitted position is, that there is an escrow agreement between both the parties. In terms of the escrow agreement, what is there is that the first payments, would have to be made towards taxes and statutory dues.
First payments
would have to be made towards taxes and statutory dues. So, if any amount is put in by me into that account, the first payment would be towards taxes and statutory dues.
Now, just one thing, Mr. Paul. Now, once the real escrow account created, that means you have no control of the account anymore.
No, I don't. As a matter of fact, this was the very same issue, which was argued before your lordships, that we had some limited control. We filed an entire compilation.
Once understand. So
we have no control over the. We have no control over the
account is there.
Now
I
cannot operate the account.
Entitled to.
I cannot operate the account.
To satisfy their own loan.
I can't.
I have to pay the statutory dues.
What I have to do is, for every payment to be made from that account, I have to write to the bank, and then the bank makes the payments. That entire compilation is there before your lordships, and how the money is to be utilized, that is there in the escrow agreement itself. If your lordships can have page 39 and Exhibit 5.
59.
At page 40 is the clauses, and we have the type copy at 41, 42. 40 is clear enough, I can take your lordships to page 40.
Yes.
This is the escrow agreement,
Exhibit 5.
1
second. Yes.
Let's may I just read this at page 40. Now this escrow agreement witnesseth as follows. All the cash flows of the business shall be routed through designated account is to be executed. All revenue receipts, receivables of the project, including deposits, service charges, etc., drawdown under the facility and equity shareholders' contributions relating to the project shall be deposited into the designated project escrow account. Further, withdrawals from the escrow account up to final settlement under the financing agreements shall be permitted for the following purposes of the project in the following order. Now, the important word is, my lords, in the following order.
Okay, yes. Yes.
Now, the first, your lordships will kindly see, taxes and statutory payments.
Yes.
And, my lords, at serial number 5, your lordships will see debt repayment.
Right, okay. Yes.
So what happened is, my lords, that the money was being deposited into the account. Instead of, my lords, making the service tax payments, that money was adjusted by the bank towards its loan.
Advances, yes.
So that is the, my lords, the facts of this case.
Okay. Yes.
Now, the counter affidavit, my lords, which has been filed by the bank, if I may first take your lordship to the first counter affidavit, they filed 3 affidavits. My lords, the first is on 26/2024, is it? This is
20th 6th. Okay.
That's the first affidavit filed.
EO number 1.
Relevant
Yes.
is 11/8.
Yes.
11/8.
11/1.
11/8/2023.
No, but that's the last affidavit. I'll take your lordships to all the 3 affidavits.
Yes.
At page 5, my lords, your lordships may kindly have that page 5. My lords, the last paragraph at page 5. Before that, my lords, the terms of the escrow account are reproduced. Now, what is the take of the bank insofar as our preliminary argument regarding, my lords, that the money has to be adjusted in seriatim, my lords, that I'll just show you, lordships. It says, it becomes abundantly clear that there is no restriction or bar for the bank to adjust money from the receivables in the said escrow account in the loan accounts.
Yes.
Now, I'll read from the top, my lords, so that this will be clarified. The respondent bank humbly states that so far as the escrow agreement dated 20/2/2015 is concerned, the same had been executed between the petitioner company and the respondent bank, admittedly for a sanctioned and second term loan of 8 crores in addition to the first term loan of 22 crores, and the second sanction was based on the escrow agreement. From the bare perusal of the escrow agreement as lifted from the said agreement, which I have already read before your lordships, I'll skip it. It becomes abundantly clear that there is no restriction or bar for the respondent bank to adjust money from the receivables in the said escrow account in the loan accounts. So what they say, my lords, is that if any money comes in, there is no bar. We can take our money first, and then, my lords, irrespective of the fact that it says in the following order, they can very well take away the money. That's, my lords, my humble understanding of this.
Similarly, there's no bar.
My lords. So at page 6, my lords, if your lordships kindly have a look at page 6.
No, but see, the other statement after that, generally there's no bar for the purchase company to pay taxes and salary payments from the receivables.
Well, I cannot operate the account. The moment it is an escrow account, I
That
cannot.
the court has to, that is what
Well, to that extent, I'll take-
whether, once escrow account created, as the first question was whether you have any,
Control over the
control
account.
over the account.
I don't, my lords. I don't have a passbook. I have statements. I don't have a checkbook. I don't have a card. And I'll show how your lordships this account is operated. From the day of opening, my lords, how this account has been operated, that entire correspondence we filed before your lordships.
Okay, now come. What do you want?
I wanted to take your lordships to page 6, my lords. 10 lines from the bottom, if your lordships can you have a look.
Yes. The purpose.
My lords. The purpose of any deposit in the escrow account loses its color and becomes receivables as stated in the escrow agreement, and therefore can be used by either parties through the said agreement either for payment of taxes or statutory dues or debt service and repayment. So what they're essentially trying to say, my lords, that it does not have to be in that seriatim. Debt can also be adjusted and anything can be done. 1-8. 11.
Follows.
Check. Thereafter, my lords, the second affidavit was filed by them. My lords, this was filed on 1st of August 2023. I'll directly take your lordships to paragraph 8 at page 9.
1st of August.
My lords.
Okay.
Paragraph 8, if my lords have, kindly have it. At page 9.
Yes. Yes.
That the deponent submits that the respondent bank had been adjusting amounts since 2017 from the receivables deposited in the escrow account, and the respondent bank is well within its right to adjust any reasonable amount as deemed fit and proper at the relevant time towards service and debt and repayment as is stated in the said escrow agreement entered into and executed between and by the petitioner company and the respondent bank. And it is clarified that the said escrow account is maintained and operated by the respondent bank, and any statutory payments, taxes, if required to be paid, if required to be paid to such statutory authorities, the same can only be paid by the respondent bank on the basis of standing instructions mandate by the escrow account holder, that is petitioner company, and on receipt of connected invoices, tax returns and amounts for proper provisioning and appropriation under the appropriate head of tax in connection thereof. But in the absence of the same, the respondent bank cannot be held responsible or legally expected to apportion any amount from receivables credited by an entity where tenant or otherwise in the escrow account for payment of statutory dues, taxes in random. It has also been established without an iota of doubt that the petitioner company is not only a defaulter of the bank but also government authorities, and it has been charged not less than by the GST authority itself for gross violation such as non-filing of GST returns for 4 consecutive financial years, so on, so on, so on. It's not relevant. What I'm trying to demonstrate from here is, my lords, it's an admitted position that only they can operate the account. The query that fell from your lordships. Even if I want, my lords, I cannot operate that account. What I have to do is I have to write to them. When I write to them, my lords, on the basis of that, then they debit the accounts. However, insofar as, my lords, these adjustments made by the petitioner, by the respondent bank, insofar as, my lords, towards their repayment is concerned, there they did not seek any mandate from us. These amounts were unilaterally just deducted. And that, my lords, was borne out in the statement that is filed in the writ petition before your lordships, my lords. The statement of account, it shows that regular deductions have been made from the amount towards the repayment. And that's not something that is disputed before your lordships.
Right, okay. Yes.
Now, in the face of this assertion made, my lords, interestingly, the bank then files a third affidavit. And that affidavit is filed on 11/8/2023, which my learned friend was very eager to show before your lordships. Now, in paragraph 2, my lords, for the first time, and my lords, this is in the face of the assertions made in the previous affidavit, paragraph 9. This statement is made in paragraph 2. Your lordships may kindly have a look. May I read, my lords?
Yes.
It starts with that the respondent bank.
Yes.
My lords. That the respondent bank had earlier filed an additional affidavit on 1/8/2023 stating that the stand of the respondent bank on the issues and queries raised by the Honorable Court, as well as by the petitioner, when the same was taken on board. Subsequently, after filing of the additional affidavit by the respondent, 2 crucial documents were discovered which answers the pertinent question as to whether the petitioner had utilized and operated the escrow account number so-and-so, and or the respondent bank had only had the sole authority and right to operate the escrow account. Now, in the previous affidavit, your lordships have said that they categorically assert, my lords, that they are operating the account. And they say that
request.
I'm sorry, my lords.
And payments would be released on request.
Only on my request.
Petitioner, yes.
So now, my lords, for the first time they come up, they said somewhere deep down in the pocket, they found out some two documents and my lords, they want to bring it by way of this affidavit. The said two documents are extremely crucial, omnipotent and unavoidable legal necessity for the Honorable Court to arrive at a just and proper adjudication of this case, my lords. The deponent states that after thorough search and scrutiny of the accounts and also the files pertaining to the said loan account, crucial evidence has been found which proves beyond any reasonable doubt that the said escrow account had also been operated by the petitioner, which is evident from the transaction dated 6/3/2020, when the petitioner, represented by its managing director, Shri Mevin Taurus Marbanyang, had utilized the fund deposit from the said escrow account number so-and-so for an amount of rupees so-and-so, RTGS payment to a third party, one Shri K.S. Khargungor, by issuing an account pay check bearing number so-and-so of so-and-so, duly signed by the said Mevin Taurus Marbanyang in his capacity as managing director of the petitioner company. An application pay and slip RTGS NEFT voucher dated so-and-so was also duly signed by the said Mevin T. Marbanyang, completes the transaction. In fact, the statement so-and-so filed by the respondent bank pertains to the said escrow account also validates such transaction. Now, my lords, may kindly pause here for a second and kindly note these two lines.
Yes.
It says, my lords, the additional affidavit filed by the respondent bank on 1/8/2023 pertaining to the said escrow account also validates the transaction dated 6/3/2020.
Yes.
I'll come back to this, my lords. I just request your lordships to kindly take note of this line, which clearly establishes that an amount of so-and-so had been debited from the escrow account on so-and-so and transferred to the account of Shri K.S. Kharkungor through RTGS transfer of fund from the deposit maintained by the said escrow account. So, my lords, may again kindly pause here for a second and see that they say, my lords, there was an RTGS transfer made from the deposit.
Yes.
Now, there are two things, my lords, if I may pause here. A, my lords, I can operate an account on two ways. A, my lords, either I issue a check, or, my lords, I make a request to them in their RTGS form to make an RTGS transfer. It would be, my lords, absolutely preposterous for somebody to suggest that
account payee check is deposited and payment made to RTGS.
And, my lords, if I may, the account payee check is not in favor of the bank. The account payee check that they have now, well, let's say that it is omnipotent for the purpose of adjudication, is in the name of one Mr. K.S. Kharkungor.
Yes.
I'll take your lordships to that check. They have annexed it at Annexure 2.
But RTGS is transferred by anyway.
No, my lords, I don't understand how both of them can coexist. I'm sure my learned friend will come.
It has to be there.
So, my lords, in that event, my lords, for every RTGS transaction, there would have been a check.
Yes, check has to be there.
Very well. We'll see that also, my lords.
Check has to be there. Without a check.
If my learned friend, my lords, if I only request, if my learned friend is making that statement,
yes,
my lords, may kindly take note of it, because I'll go back to the statement of accounts now.
Okay. Yes.
First, your lordships may kindly come to page 10, my lords, Annexure 1. I think it is the other way around. Oh no, it's correct, my lords. I'm sorry. Where's Annexure 1? 1 is 2, 1 is
Annexure 2.
My lords.
Yes.
I think it's wrongly numbered. Lordships, kindly see, this is a cross check in favor of K.S. Kharkungor.
Yes. Yes.
Now, my lords, they say that I was operating the account and therefore I have issued a check. Very well, my lords, if I've issued a check to K.S. Kharkungor, this check would then be with the original check would be then with, my lords, the bank where the money is debited, credited, not with the debiting bank. If I issue a check, my lords, to my learned friend here, who probably has an account in bank X, my lords, the moment it goes for clearing, my lords, the original check will be in bank X.
Yes.
The issuing bank will never have that original check. That's number one. Now let's, on the very same day, the subsequent page, your lordships will kindly see Annexure 3 at page 11.
Yes.
My lords, is the RTGS receipt.
Yes. This was made by the petitioner only.
This is an application. We give the application, my lords.
RTS form with the check.
No. Check cannot be there, my lords. Why? I'll show you, lords. I'll show why check is not there. Now, if your lordships kindly have back, where I had requested your lordships to kindly pause.
1 second. Now, beneficiary account number. And what is this next number?
I'm sorry, my lords.
Of SBI so and so. Okay. Okay, yes, please continue. I'm trying to figure out beneficiary account number so and so, SBI.
That's the, my lords, is the IFSC code.
Okay.
That's the IFSC code, my lords.
No. I mean, this annexure. Annexure 2, the account number.
First is the name, second is the
number is the beneficiary.
And third is the IFSC code number, my lords.
Of the bank, yes.
My lords, where the money is to be transferred.
Right.
Now let's, if I may take your lordships back to that so-called statement that they were referring to say, my lords, that that RTGS was on the basis of, my lords, that entry in the statement of accounts will clarify everything. Your lordships may kindly have that affidavit of 1st August. So they've been kind enough, my lords, to file the entire statement of accounts. From that compilation, take out those letters.
Yes.
In respect of this transaction. It's there.
This was made in which this RTSP is.
So I'll take your lordships to that relevant entry, my lords. Your lordship will find up at page 47. Your lordships have it, my lords. Page 47.
60/2020.
My lords. No, your affidavit. 1/8.
Not here. Yes, K.S. Kharkumar.
My lords, 6/3/2020. RTGS out.
Yes.
UTR number so and so. K.S. Kharkumar, 26,53,561. Now, this particular column, my lords, where your lordship will see that XXXX.
Yes.
There are these 4X. Now, what is this column? Your lordships will kindly have a look at page 12.
Instrument number.
So, if it is by way of a check, my lords, that check number would be there. That's number 1. Now, the second thing what my learned friend was trying to say, my lords, that every time there's an RTGS, there would have to be a check. Your lordship will kindly see that there are numerous NEFT transactions, well, as I can see. I'll just point out an RTGS transaction as well. Now let's kindly have page 19.
19.
19. This is only for the purposes of demonstrating what my learned friend is saying is not correct. Page 19, my lords, may kindly have. It's one on after the threats. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
The 31/3/2017.
31/3/17, my lords. RTGS.
Yes.
There's no checks. NEFTs are also, my lords, online transactions. There are no checks because here the advice is given by way of a letter, and I'll show, my lords, what is the procedure that is used for the purposes of operating this account and how it is operated.
Okay.
Now, my lords, having demonstrated this, I'll take your lordships to my reply. We filed a rejoinder, and this rejoinder was filed, my lords, on 28/8/2023.
Yes.
Where is the request? Well, if your lordships, can you have page 26, annexure 6 first? Now, page 27, Annexure 6. On 6th of March 2020, Millets.
Yes.
So this is a letter written by us, Millets. We write, Dear Sir, in regards to the fund transfer by Reliance Digital Platform and Project Service Limited against stamp duty, we are enclosing herewith the quotation in original submitted by the empaneled stamp vendor, namely KS Kharkungor. We are to request you to kindly remit the funds as per the quotation directly to the vendor. The details of the amount are so and so, Millets, that the account number, IFSC, and the amount, Millets, is mentioned over here. This was given by us to the bank on the 6th of March 2020.
Yes.
And the next page, if you lordship, can we have page 28 and just 7? This is the email we received from the bank.
Yes.
And this is received on the 27th of June, 2023. They say, Dear Sir, Madam, as per your letter and as per letter of Marbeling Projects Limited dated 6/3/2020, we have remitted an amount of so and so to the said stamp vendor, said to be vendor of stamp as a stamp duty via their UTR number so and so on 6/3/2020 in the mode of RTGS.
Yes.
So this is their letter, Malaja. It's nothing to do with me. I make a
Where did the check come from? If you made a request for transfer of amount, then what necessity of?
There is no necessity of a check. That's what I'm trying to humbly submit before your lordships. There is no necessity of a check. And that entire compilation, Malaj, we filed of the correspondence. Every time, Malaj, even if a labor payment of 20,000 rupees is to be made, we have to write to them. This is the original voucher. This is the amount that needs to be paid. This is the account details. Please transfer the money. And they do it and they send us an acknowledgement saying that it has been done. I, Malaj, in essence, have no effective control over this. And that was the correct position which was stated on affidavit before lordships on 1/8, paragraph 9.
Yes.
Now, interestingly, Malaj, the check comes out.
Was the check ever acted upon?
Malaj, as per their admission, there is no check I acted upon. This is their letter.
Yes.
And if at all, Malaj, I had given a check for the purposes of RTGS, it would have been addressed to the bank. When sometimes what my learned friend is trying to suggest, Malaj, sometimes when we make an RTGS, we have to give a check to the bank. We say pay yourself. I don't say pay Mr. X, pay Mr. Y, pay Mr. Z. When I say pay yourself, Malaj, then I give them the mandate to deduct my account and transfer the money on the RTGS.
Okay. Yes. Now,
Malaj, now, I'll take your lordships, Malaj. We had filed that entire compilation of documents, Malaj. Your lordships will find a spiral binding.
index of disbursement.
Malaj. And we've given a table in front, Malaj, where kindly see first entries of 16/3/2015, and your lordships will kindly see at page 1.
Yes.
Now, how payments are made, my lords, with reference to the subject side, if my lords have it. Page 1, my lords.
Yes.
With reference to the subject as mentioned above, we are to request you to kindly disburse an amount of 35 lakhs, so and so, only for payment to our supplier, so and so, my lords. We have to give the details, how much is to be paid. So, well, these are the series of letters that your lordships will see that where we give the details, and the subject is always, well, it's disbursement of fund. Yours, this is to be paid back to the bank. Yes, yes. That also is authorized by us. Yes. Now, if your lordships, can you have a look at page 49, Melons?
Of the compilation.
Of this compilation. This is a letter of 9/2/2016.
Yes.
My lords, your lordship, to kindly see that this is again a payment advice, my lords, disbursement of funds. We request that please pay so and so, so and so, so and so. Third entry is very relevant, your lordship, may kindly have a look.
Yes.
Yourself, tax deducted at source, 8,695, recovered from Otis Elevator Company, enclosed from ITNS 281. So any amount which is to be paid to the bank is also, my lords, there has to be a written advice by us, saying that please do this. And then it is acted on by the bank. Because next to it, your lordship will kindly see there's a handwritten note. It says disbursed on 9/2/2016.
Right, okay.
Now, my lords, what was sought to be urged before your lordships that we have never advised them to make any payment towards GST. Paragraph 9, my lords. Even though they say we have control, but you never told us, so we never paid. My lords, may kindly have a look at page 99.
Of compilation.
My lords. So 9/9/2017, minutes.
You mean to say that from 17, after the rollout of GST, there was no payment at all?
No, my lords.
Escrow account.
No, my lords. Your lordship, this letter clarifies this entire thing. If I may just read this letter.
Yes.
Submission of GST invoices and release of GST amount. Dear sir, as per discussion with you that the service tax has been replaced with a new GST format from the month of July 2017. In this regard, we are submitting the invoices of all our tenants as per the GST format for your kind information. We are to state that our rent gets credited along with the amount of GST in our escrow account. So in this regard, we are to request you to kindly make arrangements for release of the amount of GST as per the invoices so as to enable us to file the returns to the concerned department. We also take this opportunity to request you to kindly expedite the matter in relation to a pending service tax proposal as discussed not relevant, my lords, for which your act of kindness ever grateful. Bottom right hand corner, your lordships will kindly see there is the signature and seal of the bank. Next page, my lords, page 100. Again, this is again another letter of 7/10/2017. We are enclosing here with invoices of our tenants, my lords. We are to state that we won't be able to file our GST returns unless payment of our GST is released. Kindly release amount of GST as per invoices. Copy enclosed.
Yes.
Again, my lords, on 10/11, same letter is written, my lords. 7/12.
Yes.
Then, my lords, at submission of GST enclosing so this is 15/1, so 103. These are all, my lords, at 104. The lordships may kindly see.
5 till 104. So
104 is relevant, my lords, because there was a meeting.
yes.
Well, as in continuation of our last meeting, we are to remind you to kindly disburse the amount credited into our escrow account by our tenants. In this regard, we are submitting the invoices of all our tenants as per the GST format for your kind information. We are to state that our rent gets credited along with the amount of GST in our escrow account. So in this regard, we are to request you to kindly make arrangement for release of the amount of GST as per the invoices so as to enable us to file the returns to the concerned department. Now, insofar as control of, my lords, what is my control of these accounts, that will be clarified at page 111. Your lordships may kindly have a look at page 111.
See the page 108 also.
108, I'm sorry.
You flagged it, reminder, last paragraph.
My lords, yes, this is again a reminder, my lords, dated the 29th of May 2021, where we say,
no, you read this part that,
now due to this error,
your account of your bank, unfortunately, your banks have to adjust all rental deposits towards the loan amount, or even ensuring that statutory taxes, duties, which GST be left on the account for payments to the concerned authority, which don't contravention
of the escrow agreement dated so and terms and conditions of the letter dated 3/2/2015 issued by your bank. Then subsequent paragraph, my lords, your lordships may kindly have a look.
Yes. No, that's okay.
Now, due to this error committed by your bank, Marbling Projects is unable to pay the statutory taxes, including GST, and due to this GST department Shillong has sent a notice dated so-and-so, which is in turn is creating unnecessarily burden on MPPL. Although escrow agreement dated so-and-so is very clear that the statutory taxes and duties would not be disbursed by any of the parties. Release the funds for statutory dues.
Yes.
Now let's, insofar as my operation of this account, your lordships will kindly have a look at page 111. My lords have page 111.
Yeah.
But this is a letter dated 22/6/2015. It says, my lords, in connection with the above, we are to bring to your notice that most of our clients, lessees, transfer their rents payments through RTGS from different parts of the country, and as such, it has become very difficult for us to keep track of our accounts and the amount which has been credited into our account. So in this regard, we are to request you to kindly allow us for net banking for viewing only.
Yes.
Kindly change the mode of operation in the system authorized signatory against 3 numbers of accounts as details mentioned below.
Is dated this letter?
Well, it's this letter 22nd 6 2015 minutes. And well, it's the next page, your lordship, and can kindly have a look. We had made a request, but that was never exceeded 2 minutes, never reverted back to. So we write, my lords, on 11 June 2019, respected sir, with reference to the subject, we write to request your kind self to kindly grant us permission for operating our account number so-and-so for salary payment and other miscellaneous transaction for our smooth business operations. We are in your deepest need of hand for operations. Well, that's it, but never. So if I have, my lords, the right of operating, there is no question of seeking permission from them. Earlier, my lords, we could not even view. So then when we made a request to them, at least we could view that these are the transactions, there's the money coming in, it is going out.
Yes, Sujata. Anything else?
In sum and substance, my lords, they could not have taken away the money which they have. And they don't deny the fact that they have.
The thing is that from what we can see is that if the escrow agreement had provided for such, so deviations, who's liable and culpable for that?
Well, it is admittedly the bank. Because the money has been taken not towards other payment, it is only towards repayment of their loans.
Yes. Also hearing.
Have we made a computation? How much has been deducted?
Yes.
I have just made a compilation, small compilation. It will clear everything. Because all these are technicals. So it will, whichever way the case goes, but it will.
What is this? What's the arguments based on it?
You know, first and foremost, I think that has to be understood.
Yes.
What is an escrow agreement?
Right.
By definition, dictionary meaning, we know it. Everybody, most of us know what is escrow mean. But here, generally, in commercial terms, escrow agreement is executed under when a particular project is involved.
Yes.
Now, if your lordship remembers, my friend had also spoken about the loan, 2 loans. One is 22 crores, first term loan, and the second is the 8 crores. That is total 30 crores. Now, what is the mode of loan? That is term loans. And it is directly connected with the project. And what is the project? The entire hub. I'll not go to that extent. Now, why an escrow account is created? It is not for daily use. That I take out money, use the passbook. No. It is a specialized account. We have to understand that aspect. It's a specialized account meant only for the purpose of running the project. This is number one. Number two, so the bank can keep that because there is no cash credit account. Here only the term loan account, because if there had been a cash credit account, then proceeds would have been routed from there. But here there is no cash credit, only term loans, and in case of project finance, escrow account is executed.
Yes.
It is the mandate. It is the mandate of law. You have to do it. Now, what comes in and what goes out in the cash credit account? Basically, Your Lordship, all the proceeds, and by meaning proceeds, lot of things come into play. So whatever they do, if they earn 1 rupee, it has to proceed through that escrow account. It is exactly opposite to the cash credit account, because had there been a cash credit account, the proceeds would have come. Now, in the escrow account, all the proceeds comes, and there is an important line in the escrow account till the payment of the entire loan facility.
Yes.
There is a line, there is a specific mention of the line. That means the escrow account survives through the currency of the loan till the accounts are closed on payment. Now, my learned friend has said that on the top is the priority is the tax, and the rest are ours. If your Lordship goes through that, if your Lordship recalls, only first point is that tax and services, tax and service dues, and the rest ours. All. If the remaining 5 units, ours. Ours means the bank.
Due to the bank, yes.
Yes. Now, escrow agreement is a part and parcel of a financial contract. It is not an isolated agreement. It is a part and parcel, an inherent part of a financial agreement, commercial agreement, everything. Commercial contract. So, it cannot be seen in as I had stated earlier in the last hearing also. The Lordship remembers that we had filed one original application for recovery of yes. Now, there also this escrow agreement finds reflection. I bought.
Has been brought in record.
Yes.
By affidavit, no.
No. It is the downloaded copy of the file, along with evidence. Only that part. Only. I'll give it to you. Have it.
I don't know what you're referring.
Lordship, come to page number.
You're taking about today, these ones?
Yes.
This is filed for tribunal.
Yes. This is the uploaded copy. Because nowadays we have to upload the entire. It is notarized and an uploaded copy.
Which one?
OA 103. Kindly come to page 13, Your Lordship.
13.
We have enclosed the documents. Security, the defendant number 2 and 3 in their capacity as the managing director and the director of the defendant number 1 company signed and executed the following loan cum security documents as stated here in blue. The last is the number 7 is the escrow agreement.
Okay.
So, and even they have prepared a sufficiency application wherein also they have challenged this escrow agreement before the tribunal. I will come to this aspect later on. I'm just pointing out. Now, so for the settlement of...
Okay, one thing, Mr. Datta, you're saying that whatever receivables from the commissioning of the project, correct? Once escrow accounts created, whatever receivables from any quarters, they are to be
routed through that.
Routed through the escrow account.
Right.
So if suppose tenants are there, like as you can see in the documents we read earlier, tenants are there, they're paying the GST component also of their rental, whatever dues. Now, won't that amount necessarily have to be kept aside to satisfy the
I'm coming to that. I'm coming to that. Why it has happened?
Why it has happened then? Fine, I understand. You have full charge with because primarily that has been created. You have.
That's why I'm coming. Because we have to, we have to understand the nitty-gritty of this thing because it's technical thing. That's why at the very outset
I'm trying today to understand nitty-gritty.
Then every time
no, you hardly come because it's virtually. But then even then, fine. Whatever we can finish, we'll try to finish. See, the court has to understand the basic. You see, there's some basic parameters which the court has to understand. We're not a technical person. I'm not a banker nor a so the thing is that we are to adjudicate only on whether
on the basis of the records.
Yes, on the basis of the records.
Right.
And from what I understand, reading is that escrow accounts created, and your submitted just now that all receivables now will have to be routed through the escrow account itself to satisfy the payments. So you said okay, payments. And to satisfy, more importantly, the debt repayment.
That's why I was not coming to that.
Receivables are going to escrow account. What amount will they have them to service?
I'm coming to that. I'm coming to that. Please. What has happened here? The basic question that has arisen, or the controversy that has arisen, is that whether the GST component.
Yes.
Component. I'm using it. I'm coming directly to the point. There's a component was to be released by the bank. That is what the moot question. Now, before I answer to that, let us come to their writ petition. They have remained silent on this aspect. We have never said that we will not pay. We have never said. Kindly, there are two aspects of the matter. 2019, the loan accounts have been classified as NPA. That means one, yes. And escrow account is also part of the transaction. Now, see the letter here. It is Annexure 48. Page 48, Annexure 9 of their petition. They have remained silent on this aspect here. They are saying that we are not releasing the GST amount, so and so, so and so, so and so. Fine. For a moment, we are guilty. But this letter speaks otherwise. May I read, Lordship?
Yes, please.
As per the records available, it is found. It is written by the GST authority to the petitioner company.
Yes.
As per records available, it is found that you have migrated to the GST regime from the erstwhile tax regime wherein you had registered yourself as a service tax assessee and had obtained registration number so and so. The quantum of outward supplies.
Yes.
Kindly see. The quantum of outward supplies reflected in the GSTR1 returns you have filed from July 2017 to May 2020 is tabulated below. Let us keep this table. Now comes the crucial part. From the table above, it is inferred that you have effected GST transactions with taxable value amounting to rupees 20 crore 87 30 496 only, and corresponding GST totaling to rupees 3 crore 36 lakhs 14,162. However, it is found that you had not filed a single GSTR 3B return since the rollout of GST, that is July 2017. Therefore, it appears that you have defaulted in payments of GST and also passed on ineligible admissible input tax credit, thereby rendering yourself liable to be attracted towards the suitable legal provisions.
Now, what is this GSTR 3B return? It is not filed with the bank. It is to be filed with the GST authorities. And once, because the GST component has not even quantified. Now, kindly turn the next page. It is again interesting. It is 2021 letter. Further, you are requested to furnish the following documents to this office on or before 1st July 2021. What are they? Month-wise sales ledgers from July 2017 to May 2021. Is the bank is going to supply to them? Month-wise purchase ledgers, July 2017 up to May 2021. Sales invoices from July 17 to up to May 2021. Purchase invoices from July to all these, because why I am reading here? These documents are mandatory because once you submit to the GST authorities, your GST amount gets quantified.
So you mean to say that the only lapse in their part is as good as not filing income tax returns?
Because see, Lordship, the amount gets quantified.
Whatever it is has been credited, payment made has gone to the escrow account. But then the only fault is that they does not file the returns.
Because how do we release the amount?
So exactly.
Lordship, how do we?
So that they
for a moment, let us say that I agree to their proposition that bank has to release the GST component, but how? Because on the very first,
you're saying that a lapse on their part because they didn't file the returns, you do not know the GST component also.
How do I know?
So all receivables that were there, happily took them.
Yes, that has to be quantified. Year-wise quantified.
Okay.
How do we know?
Yes.
Now, interesting or not?
So I can take it away. Well, I don't know.
Let me finish.
Sorry to interject.
Let me finish.
Yeah.
Now, what happens? They have shown the letters. There are out of the entire letters, only four have been received by the bank. Others have not been received. There is no signature, no receipt. Only 4. Still, I admit that these letters have been given to us. Now, if they are saying that we have filed submitted invoices. Now, if you have filed invoices, then you have not filed there. Where from the invoices coming? The GST authority is saying that you are required to file these invoices, and here you are saying that we have filed invoices along with this. Where from? Not a single invoices had been adduced along with the additional documents or the petitions. Where are the invoices then? This aspect has to also to be considered, because all these are matters of evidence. And even if for a moment we stop on this point, the other technical question arises, because the escrow account and all these things are before the DRT. This is that escrow account is escrow agreement is a financial agreement, and a part of that's the same transaction. And basically, what the repetition says, in one line, they are claiming a certain amount from us as a set off. Because they are saying that you have not paid our GST amount, and on the other hand, you have taken away, adjusted the said amount in the loan account.
Okay, yes.
This is their stand. This is their stand. In their application also, it is the same stand. Now, if you take that statement, that assertion, then this section 19A Just a minute, I'm giving you this here. Section 19.6, 19.7, 19.8, 19.9 and 19.10A of the RD and B Act applies. If I may read. May I read, Lordship?
Don't have copies of that.
Well, this is the Recovery of Debts and Bankruptcy Act.
Yes, I'm sorry, I bought a single book.
No, we have it here.
Courtmaster, this is the Recovery of Debts and Bankruptcy Act 1993.
It's here. Huh? So because the act was kept
changing.
So we could change the courtroom. Yes.
19.6.
So why you bring legislation? Why you bring the element of set off here?
Yes.
Why you bring the element of set off here in this argument?
Yes.
Because we are concerned with
because it is essential because.
Okay.
Why? Because this part, as I am repeating time and again, because it is not that we are taking advantage of this. No. If your lordship kindly allow me to read very fast, I'll read.
Yes.
Where the defendant claims, because they are the defendants in the OA,
yes.
Where the defendants claims to set off against the applicant's demand any ascertained sum of money legally recoverable by him from such applicant, here the applicant means the bank.
Yes.
The defendant may, at the first hearing of the application, but not afterwards, unless permitted by the tribunal, present a written statement containing the particulars of the debt sought to be set off, along with original documents and other evidences relied on in support of claim of set off in relation to any certain sum of money against the applicant. Next. The written statement shall have the same effect as a plaint in a cross suit, so as to enable the tribunal to pass a final order in respect of both of the original claim and of the set-off. A defendant in an application may, in addition to his right of pleading a set-off, under subsection 6, set up by way of counterclaim against the claim of the applicant, by right or claim in respect of a cause of action, accruing to the defendant against the applicant, either before or after the filing of the application, but before the defendant had delivered his defense, or before the time limited for delivering his defense had expired. Now it is still because there is a stay order, the entire proceeding is suspended. Yes, the proceeding is suspended because the moment.
Is there an interim order?
The moment.
Order here.
Yes, there is a stay order.
Which dated when?
Staying away.
Yes, I got there.
Staying away before.
No. It is also stayed. And because they have filed one application here.
OA is not stayed, Millets.
Yes, it's stayed. I've got the order. Just a minute, I'm giving you the order, Lordship. Yes. This is the IA they have filed in original application, IA number 367 of 2023. They have filed.
They filed it for the.
Yes. They are saying
not order of this court.
No, it's not an order. Let me read. Kindly, let me read.
My lords, in these proceedings, there are no interim orders.
Yes, just read. What does it say?
Let me see. The applicant, I'm reading here. The applicant herein filed an original application, so let us forget it. The defendant herein has served with the OA paper book and has directed to file written statement. This is to submit herein that the defendant number 1 herein having filed writ petition under Article 226 before High Court of Meghalaya in WPC number 178 of 2022 against some illegality of Punjab National Bank, that the defendant by virtue of order dated 3/5/2023 and 24/5/2023 passed by the Honorable High Court of Meghalaya, Shillong in MC WPC number 56/2023 in WPC 178 titled as Marvinian Projects Private Limited versus Punjab National Bank. Thereby, Honorable High Court of Meghalaya has directed to maintain status quo till disposal of the instant writ petition.
Well, that was with regard to a notice issued by the GST department. We informed the tribunal. Tribunal has passed an order. I'll take a lordship to the order of 3523.
This miss case number 75.
Yes. Miss case is 367. Sorry, no. Miss case is.
What is that miss case you filed?
56 of 2023.
56.
Not be here. Can I
56 and 70 is also there. Yes, sure.
Sorry, wasn't having any.
And this is the order passed by the Honorable Tribunal, and it is still continuing. And neither we should move in the application, nor in the
what my learned friend is trying to do.
Mr. Datta,
going on a roundabout manner.
For cancellation of registration, the status quo on the cancellation registration of GST.
It was against GST.
Against GST to punish.
No.
It has nothing to do.
No. What I am saying. No.
Why you say that the stay on?
There's no.
Because this is the order. This is the order.
That was the tribunal. What is the proceeding? What is a different issue?
No, I am not saying because what I am saying on record that the tribunal has to state the proceedings.
Right.
For what reason I have not said here? For what reason I have not said?
Say that the petitioner misrepresented the orders of this court before tribunal. Are you implying that by the application they made? Because the status quo is only with regard to the cancellation.
Cancellation of both the orders are next.
Registration because they failed to file return.
I am not imputing anything. What I am saying.
No question of. Right, that means the stay is not by this court.
Yes.
Because this court not stay any proceeding for that.
But it has been placed before the tribunal, and tribunal has, can you see? This is the past order. And it is still continuing. And you see.
If the tribunal has stayed its proceedings, there are remedies available to the bank. OA proceedings are not before your lordships. I don't even know which order my learned friend has placed.
This learned counsel and Sharma appear to defendant so and so when a prayer proceeding became abeyance till disposal.
Yes.
Once a prayer has been made. There is a stay.
WPC is what?
It's just mentioned.
No, this petition.
Mr. Datta, you can't make this kind of submission because it's not a stay order. It just says that with a prayer to keep proceeding OA in abeyance. If the tribunal kept in abeyance, that is.
I am instructed, Malaj, that the OA is actually proceeding. That's what my friend.
No. It's not proceeding. It is not proceeding. It is there.
Yes.
Lordship. Lordship.
We'll do tomorrow.
Lordship tomorrow.
Yes. One we already in the field myself completed.
Yeah. All right.
I'll be clear about the
I'll come, Lordship. I'll come.
Conclude this matter, Malaj.
Yes.
I'll come.
But in partly tomorrow for further hearing. You take this order back and you read it clearly. It does not say anything about.
No, because I am not saying that because that petition has been filed by them, and that what can I do?
When you file a prayer and order are two different things. It's like the night and the day.
Because even the surface is stopped. Because if your lordship remembers, we had issued one notice. They had your lordship stayed because of this particular proceeding. That was also placed before the tribunal, and tribunal stopped. So as on date, your lordship, both the cases are not moving.
Yes.
That's the thing.
Item 24. Yes.
24.
We'll continue tomorrow.
Oh, I'll come.
On a lighter vein, though, Malaj, what my learned friend is submitting, I was reminded of a small anecdote. There seems to be a circumstance, Malaj, where a certain product is lying unclaimed, so to say. Even though I know whom it belongs to, Malaj, I decide to take it away. And then in my defense, I say, Malaj, it was lying unclaimed, so therefore I have a right to take it away.
24.
Tomorrow, lordship, come.
I pray for time, lordship here.
You waited for so long, you might as well complete the matter.
I have
Where's the other side?
Mr. Karmi, I have informed Mr. Karmi.
Mr.
Mr. Karmi for the other side, lordship.
Is the conducting counsel.
What's the matter about?
This is the less important.
Teacher appointment?
No, no, VC Lordship.
VC? Okay, we'll give you time. After 2 weeks. Right.
25.
25.
Yes.
May I please, Your Lordship? Your Lordship, we just enter appearance, Your Lordship, in this matter, Your Lordship.
Election petition?
Yes, Your Lordship.
And then enter appearance on behalf of whom?
For the petitioner, Your Lordship, he have come.
What happened to the earlier counsel?
I don't have any instruction, Your Lordship,
The
but
file application has been withdrawn. It's on record.
I don't have any instruction, Your Lordship.
No, you can't just see the thing. The election petition is very technical. Everything has to be on record. Who's the earlier counsel?
Yes, Your Lordship.
Who's the earlier counsel? Let's see the order sheet. Mr. P. Sunar, MSP Sunar, A. Joshi.
Shantanu, Your Lordship.
Who?
Shantanu, Your Lordship.
Who?
Shantanu.
S.K. Nongrum, M. Prasad, A. Kumar. Oh no, sorry. R. Paul. Who's this? Amit Joshi is whom? We won't pass any orders. We put in a proper application today itself.
Your Lordship, can you give us some time, Your Lordship, because...
How will we give time? We can't give time. This proceedings, we are bound by procedure. We can't give the, you have to put in a proper application. That's also withdrawn, and even whether he's withdrawn or not.
Because we just received the instruction, Your Lordship, from the petitioner only, like he have appointed us to do this matter, Your Lordship.
Then when did you receive the instruction? Just now? How many minutes ago?
No, yesterday, Your Lordship. Night
Then you
time.
should have put an application. You put an application for adjournment, then you pass up, you file a proper application.
One this time, Your Lordship.
You put an application, you can't pass the orders.
28.
Much better.
Put it now, put an application. We'll consider. What happened before the Commissioner?
Your Lordship, as per my instructions, the inquiry is still going on, Your Lordship. Some witnesses were called today for examination.
Yes.
Yes,
You
Your
appeared for the Commissioner?
Yes,
You
Your Lordship.
appeared?
Yes, Your Lordship.
Still going on inquiry?
Yes, Your Lordship. Still
Just
going on.
for cell track certificate, it takes 2-3 months.
Your Lordship, I have a prayer that this matter may be closed, Your Lordship, with the direction to the scrutiny committee to complete the inquiry within a specific time frame.
If we close it, that means the no outcome will be there till another 5 years.
Your Lordship, because this the issue with regard to the scheduled type certificate has to be determined by the scrutiny committee, Your Lordship.
Exactly. Well, why is
So
taking
if a
so long?
time frame is given, Your Lordship, they may be directed to complete it within that time frame.
Yes, MSRE non-country today, yes. Here difficulty, yes.
He lost his original certificate, my lord.
They can't find the replacement. They said all the records are burned, so they have to have some, what they call it, fail-safe mechanism when such things happen. Yes, I think it's informed that the hearing is yet to conclude. Stop. The same is also corroborated by the counsel of petitioner. Stop. It is noted that this matter has been hanging fire for how many months?
It was filed last August, Your Lordship.
For substantial amount of time. Accordingly, it is directed that the set proceeding for the petitioner should be completed within a period of 8 weeks from today. Yes, this accordingly. Copy of the order be supplied to the learned GA.
Your Lordship, will the matter be closed or will it be
No,
left?
we're not closing it.
Obliged, Your Lordship.
30.
Yes.
Yes, Your Lordship. Nehu Council.
Project officer. Where's
Standing.
Mr. Sen?
Mr. Sen.
We can't come it today. We'll have it on next week. Yes. Urgent.
Yes, sir. Lordship, if it could be after 2 weeks, Lordship.
Why?
Lordship, I'm not keeping well since yesterday, so.
Okay. Stop.
I thought of doing it today, but we have paucity of time.
This is matter for 2 weeks. Yes. Due to paucity of time, take up the matter today. Yes.
Much obliged.
31.
Yes.
Yes, Your Lordship.
Your Lordship, on the last date, we have filed the list of and the chronology of the cases and the suits pending before the District Council Court and before the Additional Deputy Commissioner. Your Lordship, in accordance with the list that I prepared, the affidavit that I filed, the title suit 15 of 2018 has been disposed of. The suit of the plaintiff has been dismissed.
This is.
I have the order.
This is the title suit of
2015 of 2018. 15 of 2018, Lordship. Pending before the District Council Court, July.
Where have you given the suit number?
Your Lordship, in this separate sheet which I have filed assisting the court, which I have filed on the 5th June, 2024.
Where's the title suit number? Because title suit number 221 still pending.
No, Your Lordship. The petitioner she had filed.
Sorry, what is the suit? Raj Amvi Jara Committee Institute suit title suit number 221.
Yes, Your Lordship, that suit is pending at EDC.
Yeah. Next one is Antrim Junction. Where's 18? Not mentioned anyway.
Your Lordship, it's there. I have filed, Your Lord.
Where's 18?
15 of 2018.
Where's it in this chart? This comes for you only.
No, Your Lordship, this is another right.
This is matter
under Ilaka Amvi. Which?
Okay, okay.
This right, Bhuvan, this is right Amvi.
You're the wrong one.
No, I have filed 2, Lordship.
Your Lordship, I'm not, Council has not given me a copy. I don't know what it's referring to.
I have supplied copy.
No, not to me. You've given it to the state.
What's title suit 21 then? That's number 2 then, 21.
That was filed by them. Your Lordship, it is pending now at Amram, EDC.
So, Your Lordship, title suit number 50, 2008.
Title suit pending for Amram, EDC?
Yes, Your Lordship, because the government is a party in this suit.
Okay.
So, Your Lordship, title suit number 15 of 2018 was instituted by the petitioner.
Okay, 1 second.
So, Your Lordship,
title suit 15. 15, date of filing, so granted. You hear it somebody is.
Your Lordship, I have apprised the court that I have filed an application on the order 7 Rule 11.
Yes.
And the plaintiff, who is the petitioner, Your Lordship, has been rejected. It was fixed on hearing on the 13th.
13.5 is being heard till now, no orders.
No, the order has hand over, Your Lordship, the court master.
Passed in this 711 application.
Yes, Your Lordship.
So your suit is dismissed.
Yes, Your Lordship, but then that's besides the point, because here I'm coming not as administrator of the right, you're not challenging the post of the Lingua. Yeah, Your Lordship, you're coming as practitioners of the traditional faith, Your Lordship.
Whatever it is, your title has been dismissed.
Dismissed, but then dismissed not because, Your Lordship, it has been heard on merit, not dismissed because it is the wrong forum. It should have been filed. Yes.
Dismissed, but there's no pending proceeding.
Yes, Your
Lordship.
Lordship.
For the action presently.
Yes.
And we'll see it. We'll pass orders then. A copy of the sequence of events.
Lordship, may I?
With regard to title suit number 815 of 2018 pending, which was pending with the Court of Subordinate Council Court July, has been filed. It's also an order dated 6/8/2024 has also been furnished to the court, showing that the the title suit has been dismissed for want of jurisdiction. Yes, what do you
Lordship, the controversy in title suit number 15 is with respect to the pose of window which the petitioner has instituted before the.
I'll list the matter after 1 week, yes, for the order. You come prepared.
32.
Now, if your post window is gone, what will happen?
Your Lordship, I'll also file a similar application before EDC because they are saying that they are the lingua.
Yes.
I'll file a similar application, Your Lordship, but it's a council decide then. Because we are saying that we are the lingua, they are saying they are the lingua. Our case has been dismissed for want of jurisdiction, so this similar suit should be followed.
The submission before the
EDC, yes, Your Lordship.
after 1 week we'll take it up.
All right, yeah.
Highly obliged.
Yes, Dr. Mozika, you have resolved the matter?
Sure.
No, not resolved.
Tomorrow then. We'll pass orders tomorrow.
Alright.
As per your own policy, waiting list is entitled to a seat. How you accommodate her, we don't know, but then
33.
Tomorrow.
Highly obliged, Lordship.
tomorrow as a fixed matter. Yes.
May I please, Your Lordship? Your Lordship, this writ petition is with a limited prayer, Your Lordship.
We won't take up hearing now. It's already past court time.
Next week.
When do you want it? Next week.
Obliged.
34.
Lords may put it on any other date.
The joinder file.
Well, it's filed. Hearings are complete.
Yes.
You can have it after 2 weeks
Yes,
or
after
3
2 weeks. Yes. Request of the consular. You know what happened long time ago in Amitabh Roy's court when it's sitting in Shillong. So, you know, I was arguing a matter. Then, you know, it was going against me. And then it went on beyond court hours. And so he said, okay, fine, I'm dictating the order. I said, then, my lord, I think you can't dictate. Why? Because it's past court hour, I have to go. He had a good laugh and he rose and he narrated that incident again. He didn't go at me. That's what I was telling Mr.